Higgins, Alberts, and McCabe's filed defamation suits against Aidan Kearney, and Karen Reed. And yesterday, the judge ruled on the anti-SLAPP motions that were filed by both parties. We didn't think Karen's had much of a chance. We didn't feel the same about Aidan's. We felt that that was a strong one. He denied both. Spoiler alert. Let's figure out what happened. Let's take it. Hello and welcome to Defense Diaries. I'm Bob Mata, and as always, I'm joined by my beautiful and brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, all. I hate the lighting in this with this harsh wall behind me. I can't stand it. But yes, hello, everybody.
Wow, it's all right. I mispronounce Aidan's last name every single time. So
I mean, it's what you do.
I mean, you know, it's how it's spelled. What are you going to do about it? It's like I'm pronouncing it the way it's spelled. So if I'm looking at it, without even thinking, I pronounce it the way that it's supposed to be pronounced. But at any rate, we are about to dig in on the judge's order that dropped yesterday. As everybody knows, who's been following the civil suits, the anti-SLAPP motions were filed. We gave our critique of those back, I don't know if it was 10 days ago, something like that. And we had some strong thoughts about Karen's lawyer's motion to dismiss. We thought it was a big whiff, and that's putting it kindly. We thought Aidan's was strong. I still think Aidan's is strong. You know, we will be talking about. Go ahead.
I don't think it's a big whiff. They made some big whiffs. That's for sure. But I don't think that it's got like no merit. And I'll tell you why I think that Judge Gildea actually saved them from their fuck up.
Oh,
we can
what a teaser. What a teaser.
Yeah,
no, you don't give it out now. You gotta make the people wait for that. So yeah, I mean, really, the fuck up was obviously not addressing all the new allegations that were contained in the amended complaint. You know, I mean, they did it in the reply. That obviously wasn't the place to do it, but that might have something to do with your thought process. So I guess we'll have to wait and see.
Let's give them the non-lawyer translation of what's happening here. So when the should have been House suspects filed their multi-count defamation and conspiracy lawsuit, as we know, the defendants immediately hit back with a constitutional shield called the Anti-SLAPP statute, Massachusetts specifically. So the law is supposed to protect everyday citizens, activists, independent journalists from being dragged into ruins, multi-million-dollar lawsuits, expensive lawsuits, just because they spoke out on a matter of public concern and tried to pressure the government to investigate a crime. So today we're going to read through the order line by line, and you're going to see what Bob and I see as a textbook example, the judge completely collapsing the legal framework. So there's a massive systemic difference between like your standard 12b6 motion, which is a motion to dismiss for failure to state a claim, and the anti-SLAPP. So the 12b6 is still pending. And in a 12b6 motion, the judge is legally required to basically blindfold himself, except to every single wild accusation, the plaintiff's complaint, as absolute gospel, and weigh all inferences in favor of the plaintiff. But an anti-SLAPP motion is essentially the exact opposite. The Supreme Judicial Court has made clear in a case that the judge cites here that at stage one, which is what we are at, the judge cannot accept the complaint's allegations as true, which he does here. A lot, right?
A lot.
He's supposed to conduct an objective, structural, facial review of the actual conduct and the statements being sued about to see if that's based on the protected petitioning activity. And, you know, they're supposed to take into the counter affidavits of Aidan and Karen. But I think the one for Aidan here is even more important. And they're supposed to, you know, actually consider it, not just accept what they say, and not supposed to be resolving questions of fact that deal with intent and motive, like all these things. So you got to keep that in mind when we're reading the anti-SLAPP ruling, because he treats it like a 12b6 motion from what I see. Like, he let the raw unproven allegations from the plaintiffs basically strip away at the core of the anti-SLAPP motion.
Yeah. And, you know, with the kind of the easy way to look at anti-SLAPP, and Ali touched on it a bit, is it's a way for not only private citizens, investigative journalists that are independent, anybody who is out there petitioning the government for whatever reason, from getting sued frivolously or in violation of their constitutional right to free speech or freedom of the press, for that matter. So what they did is they developed this law, and the anti-SLAPP is supposed to cut the entire lawsuit down before you get into what we're seeing in the O'Keefe case, which is the discovery. And like we've told you guys for 2 years plus, that the discovery in that thing was to be nightmarish and never ending, which has stood to be true, right? So what they're trying to do with the anti-SLAPP is avoid getting to that phase if they can. So that was why they developed the anti-SLAPP. At this point, as we go through this live, we'll kind of figure out whether or not what the next step is going to be. Are they going to just let it lay, or are they going to fight it in terms of an appeal? We'll talk about that as we go. But as Ali was saying with the 12b6, and she was talking about the mechanics of both, you know, essentially 12b6, the bottom line is you're filing a motion and you're saying, look, they filed a lawsuit, but here's the problem with that lawsuit. They failed to state a claim of action. There's no cause of action in that is going to allow them to move forward with it. So there are different mechanics in both, but I agree with Ali in terms of the portions that I've read, and Ali's done a huge amount of work. Like, that was why we were late. I was like, dude, it's over. Like, she started last night. She's been researching case law. So if you're a law nerd, you're going to love this live, because Ali has done an awful lot of work. She's looked at all the cases the judge cited, and I'm sure she's done research beyond those cases in order to craft her own arguments. I mean, I'm going to put it this way. Ali's probably at this point ready to step onto the team and you know, join the fight. So just in terms of the amount of research she's done, literally, it's like 11:53. I'm like, you got to shut the computer down. You got to get ready. We got to go. Got to go. So I anticipate that she's going to have a lot of great things for us to all learn together, because she doesn't apprise me of what she's doing when she's doing it. So we'll all be learning together at the same time. All right, babe, this is your baby here. So what do you want me to do?
Well, I think we should just first remind people, like, about the stage 1 and stage 2, and we're at stage 1 with this. So it was the move-in's burden, Karen and Aidan's burden, to show that the claims against them are based on petitioning activity. And then stage 2, it shifts to the plaintiffs to show that they had no factual support or arguable basis in law, you know, for the statements, and that there was an injury. So I think everybody agrees, if this got to stage 2, plaintiffs would be screwed, you know. But the stage 1 is about structure, right? And stage 2 gets more like to the merits of what was said. And stage 1 asks, like, what kind of speech is it? Is it aimed at the government? Is it aimed at enlisting the assistance of the public? And then stage 2 asks, was the speech garbage? Was it baseless? Is it a sham? So the single biggest criticism of this order is that the judge, I think, that let stage 2 thinking leak into stage 1 over and over when he explains why something isn't petitioning. The reason he gives is that it was cruel or vicious or aimed at hurting people. That's a stage 2 problem. Whether the speech is nasty has nothing to do with whether it's structurally aimed at eventually getting the government to do something. And I think everybody knows the 5 categories, but I'm sure it's like, I haven't read the order in a while with all of this, but I'm sure it's listed there right in the beginning. So I don't think we need to flesh those out. But one thing before we read it, there's a 2024 Supreme Judicial Court case of the Bristol asphalt, which the judge references as well, and it made anti-SLAPP motions harder to win. Okay.
Hey, before you do that,
Yeah.
I am very apologetic for interrupting you. We are 7 subs away from 70,000. Here's the deal. If you haven't subbed, please, it's free. Just shrink down the chat and hit subscribe. I don't want to have to do what Aidan's always doing. Like, he'll sit there like, oh, I'm almost to this. I don't want to have to do that. I'm just going to have faith that we can get 7 subs to get 70,000. So should I hold up the whole live until we pass 70,000?
No, but you know what you should do, because
What?
you love me so much and you want people to know how amazing you are, is
wow, it sounds like you want something to drink.
Yes.
Oh, yeah.
I'll go through this slow enough where you can come back.
Okay. Do you want coffee?
I mean,
Or
coffee
water?
and water would be amazing, but
Wow.
just water is all I really need. You mentioned coffee. I wasn't even going there yet.
I mean, I felt like you were going there. I felt like deep down you wanted a twofer. All right. I got you.
Okay.
I
Love
got you
you.
faded. Love you too.
All right. So here's what, before we get into it, and like he said, most of you already know, have probably listened to other creators about this, but this isn't like the end. Even if they lose the appeal on anti-SLAPP, it's not the end, and we'll get into it more because of the when we're going through the actual opinion, because one of the cases they cite. But here's what I wasn't sure about, and I am now. So in that 2024 case that I was saying, the court made it harder to win an anti-SLAPP because, in one sense, because here, where the plaintiffs put all the defamatory statements into one defamation, cause of action for each, one for Aidan, one for Karen, the judge can't splice up the claim and be like, well, this is petitioning activity, this is petitioning activity, this is petitioning activity, gone, this one's not. So where it's built on like hundreds of statements and 99 of them were petitioning activity, but one wasn't, that one gets the whole count to survive an anti-SLAPP motion, not a 12b6 motion, not other motions that can also be based on all the same things and get the case dismissed, but just on the anti-SLAPP, because it has this special power of staying things and the attorney's fees and all of those things. So, like, if you're thinking, well, the judge should have separated the protected speech from the unprotected speech, that's not what he does here at this stage in a anti-SLAPP. So it means like the defense has to win everything, every blog post, every video, every voicemail, every thing that he said, all of it, to be petitioning, and that's really a hard standard. But the judge doesn't even say here like which statements he's saying are non-petitioning. He just says, these are largely non-petitioning. And I think that's going to be a huge issue when they get to the appeal, which is automatic. It's going to happen. I wouldn't be surprised if it happens Monday, because it stays discovery. But while I'm waiting for Bob, let's say hi to Rally Possum. Appreciate you. Family hug. Welcome. Living Story Worlds, 27 months. Wow. Thanks for your continued support. She says, Allie, say it. We've got Dancing the Pea Patch, a new member, and Laquani. Sorry, I hope I'm saying that right. New members, welcome. Strains Credulity, if I can speak. gifted 1 Defense Diary membership. Thank you. And then we've got all of yous with your jewels and your gems, which we greatly appreciate. And let me just see if we've got any other questions. Wait, did we get 70,000? Oh, there he is.
Here, this thing is really leaning forward.
I know.
Why?
I don't know.
Here.
Bob's trying to fix my shit. He saved me. All right. So I wonder, is Bob going to pull up the order or am I? Guess that's the question. I'll just bring it up. I don't want to, I'm ignoring all you guys talk about the 70,000 until Bob comes up so that, hey, apparently we have reached 70,000.
Hey, 70,011. You guys are amazing. We did it. You guys rule. You guys rule. Thank you so much. We appreciate that. Onward and upward. Onward and upward.
All right, now we go to 100,000. Keep going.
100,000. Like, no bullshit. I'm not laughing.
Me neither.
It's crazy to me that our channel is 3 years in and we don't have 100,000. I know the quality of our content. You know, I mean, and whether you're love watching us or hate watching us, we're worth watching either way. That's just a fact, you know. And like, I don't know, aside from Ian, I think we're the only other. Well, Andrea's a criminal defense attorney, but she's really appellate. In terms of like kind of law tubers, there's not a ton of criminal defense attorneys that do it. So, you know, I think we're pretty good. We're the other side of it. We're the other side of it. So, which is important. You learn things. You learn things. You listen to both sides. You can listen to Emily D. Baker, get that prosecutorial slant, and then come over and listen to us. And then you get the defense side of it. But I'll tell you right now, this is going to be the last time I'm promoting Clancy, which openings Monday. Allie and I are going to be on a plane. I'll be on chat. Allie will be on chat while the openings are taking place. We did get excellent news. We got excellent news for us as selfish bastards that there's no court on Tuesday. So Clancy, there's openings Monday and the first witnesses, and then Tuesday's an off day for reasons unknown. So that is excellent for us. That was actually, again, selfishly, I was very, very happy about that. So, but in terms of our coverage, and I saw Peter, who we love, you know, he's like, oh, we're going to, you know, I'm going to handle this differently. I'm like, oh, it sounds like you're going to handle it like we're going to handle it. And so it's like, and we had done our primer 8 days and we had shown you the jury instruction and explained. So it's the right way to handle that case is to focus on the one issue that is in controversy, which is the criminal responsibility aspect. Because if you don't know anything about it, in terms of the case itself, the defense has offered ad nauseum. Kevin Reddington has said it. I don't know how many times that I've watched him in court on this case talking about we would stipulate to all of the homicides. We don't need to get into it. You know, he understands. And like what we're always talking about as defense attorneys, we understand. The Commonwealth is just looking to wring the pathos out of it. They want the emotion, the horror of what happened to those kids. They need it. They need it. Yeah, I think Peter and their firm, it's not to say they don't do any criminal, but they're primarily plaintiffs.
But I think the father did a lot of criminal work.
Yeah, dad.
And George did do criminal work with his dad for sure.
Oh, 100%.
Now
100%.
they're primarily plaintiffs, but you know,
I mean, they're smart.
They're both
they know
great lawyers, right? Yeah.
They're both. George is phenomenal. Peter's phenomenal. They're both great. You know, and they're smart because, frankly, civil work is where the money's at. It's hard to make a ton of money in criminal law. It just is. It's like people, you know, I mean,
and there's much more extensive legal
Josh
writing.
is a defense lawyer in name. Like Josh, and I love Josh, but he strikes me as a prosecutor at heart. Just does. You can tell a defense attorney, like a die-in-the-wool defense attorney from a former prosecutor who's turned defense attorney. And that's not to say I've met some that have gone from what I consider to be the dark side to the right side. And you can always tell, like, if they still have that prosecutorial blood flowing in them. To me, it's a DNA thing. Does Martin do criminal law? I don't know if Martin does. I was under the impression that Martin was a civil litigator. I don't know either. But I've been talking to Martin. We're going to do a collab soon. I'm like, dude, we're way overdue. It's way, way overdue. So, yeah. So that's that. But at any rate, follow us for Clancy. And to be honest with you, like, if there's going to be any time that I'm not that upset about missing, it's going to be the beginning of the case, because it's the part of the case that's, again, not in controversy. It's going to be the hardest part to watch for certain, because we're going to be talking about just the horrific events of that day and the loss of those 3 beautiful babies. It's going to be rough. It's going to be rough. So what I am so anticipating is the fight, the actual fight in that case, the criminal responsibility or the lack thereof in that case. That is where the heart of it is. That is where the heart of it is. And it's going to be important. It's going to be fascinating. And it's going to be worth your time. I know it's going to be hard. I mean, if you're of the mindset that you can't stomach watching that case, which is completely understandable. I mean, Allie and I are parents of 4 kids, so we get it, and the thought of it is unthinkable. And, it's going to be too much for some to handle. I would suggest, however, that once we kind of move past the state's case in chief, it's worth your time to come in and view what's going on there, because essentially it's the American criminal justice system on full display. And it's a huge step in whether or not we're going to start recognizing that mental health issues, mental health defects are going to be, if we're going to be able to apply the law. Because up until this point, as a country, we have a very hard time applying the law when it comes to the insanity defense, or what they call it, lack of criminal responsibility. It's the same thing, because we are very much an eye for an eye country. And most people are like, look, you did a horrible thing, you got to pay. I don't care what the circumstances are behind it. And as hard as that is to say, you know what, I've got to put the horrible thing aside and I've got to decide this one thing. And this, we've created these laws for a reason. Okay, we've created the lack of criminal responsibility statutes for a reason. They've been put into law for a reason. And it's up to us as the citizens to follow the law, to make those laws matter. Because right now, I mean, like any defense attorney is going to tell you, the insanity defense is the defense of last resort, because it's that hard to convince people, okay, I need you to look away from the horrors, and I need you to focus on whether or not this person had control over their mind, or if their mind had control over them. So, all right, enough of that. Let's roll. Oh, whoa. My channel, my rules. I was doing it anyway.
But I put it up here because I was trying to get him back on topic. So,
oh yeah. Well,
I was letting you go for as long as I did, only because
I wanted to let people come in. Like, Melanie takes a good 10, 12 minutes to allow people to flow in before because Melanie, if you watch Mel, and we love Mel, when people come in and they're asking, well, where are we at? What are we talking about? She's like, nah. It's like, you can go back and start from the beginning, and I'm going to adopt that. I'm going to adopt all of that. So I think kind of moving forward, I'd like to kill a little time before we jump right in, because I think there's a lot of people that get in late. I've seen we've had 300 people flowing in the last 5 minutes. So to that point, but all that being said, let's rock and roll.
Yes, Queen Melanie. All right. So you know, I'm not going to start with the intro.
I think I should do a lot of the reading.
You know what? You pull it up because I think that's a good idea. And then I'm going to have what I'm going to pull up, and then I'll like share my screen when I've got like
exactly, because I know you're one screening it. I don't. Tracy, did you send this to me? I don't know if I got it.
No, I sent it to you, didn't I?
No.
Oh,
maybe. If you didn't, please do it now.
Right now. See if there's any questions. I went through some of the.
Well, I'm waiting for you to email it so I can.
I know. That's why I'm saying look for that while I'm doing it. Order. Okay.
I'm sure that Kyle sent it to me.
I've got it right here.
I had to put Kyle on blast yesterday. I'm like, dude, like, are you seriously tweeting about Clancy and tagging not us?
All right, let people be.
Oh no, Kyle knows I love him. I'm gonna call him out on shit like that. Sorry. I don't consider Clancy to be off
Kyle was a girl
at all. At all.
Kyle's not a girl. Seems like the work of a woman.
I mean, all I can tell you is that Kyle's like little, whatever you call it, like the picture thing is not a girl.
Oh,
but it's a cartoon. It's a cartoon. You know what I mean? All right, did you send that thing so we can get it started?
Yeah.
The other thing, while I'm waiting, oh, yep, it came through. I've really been enjoying David Yannetti's complete roast of Voss in that article. Like, Dave's pulling no punches, and I'm here for all of it. That has been glorious. Just absolutely glorious. All right, I got it up here. Okay. All right, I'm ready to share. All righty, let's blow her up. Okay, so this is the order that came down yesterday, and let's go through it. So this is the memorandum in decision and order, or a memorandum of decision and order of on the defendant's special motion to dismiss pursuant to the anti-SLAPP law, and then he cites the statute. So the plaintiffs, McCabe, Albert Higgins, brought this action against defendants Karen Reed and Aidan Kearney, alleging they conspired to defame them by falsely stating that they were responsible for the death of Reed's boyfriend, John O'Keefe. The first amended complaint asserts claims against both defendants for defamation, intentional and negligent infliction of emotional distress, and civil conspiracy. The plaintiffs also assert separate claims against Reed for aiding and abetting in Kearney's defamation and infliction of emotional distress against Kearney for violation of GLC 93A. So the defendants have each filed a special motion to dismiss the complaint pursuant to the anti-SLAPP statute for the following reasons. The motions are denied. Discussion. So the anti-SLAPP statute, 59H, establishes a procedure for obtaining the early dismissal of a claim that seeks to impose liability on individuals for exercising their constitutional right of petition. Now, there's a few footnotes there, and he's just listing the parties. Footnote 3 states the defendants have also each filed motions to dismiss pursuant to 12b-6. Those motions will be addressed in a separate decision. Those motions will be addressed in a separate decision.
The analysis is totally different. There's no immediate right to appeal, so that is the proper way to handle it. Plus, again, in the 12b-6, you're going to go statement by statement and say in, out, which you can't do in an anti-SLAPP.
Yep. And as Ali said, there's that Bristol asphalt case that's been cited, which is really the watershed case as far as anti-SLAPP and mass. So, all right, these powerful procedural protections were intended to be employed in a limited context to ensure the expeditious elimination of meritless lawsuits based on petitioning activities alone. Again, so that's to ensure the expeditious elimination of meritless lawsuits based on petitioning activities alone. So that's what I was saying in normal talk. It's like, let's get rid of these cases that are frivolous and that are based on somebody just asserting their First Amendment rights by petitioning the government. All right. So, however, the statute has been regularly invoked in attempts to dismiss a wide array of other claims concerning conduct far afield of the petitioning activity that the legislature originally sought to protect. And again, the judge cites Bristol Asphalt. Now, you can tell, like if Allie and I were reading this, and all lawyers go right to the end to see if they don't put like on the opening page, like what their decision is, which these days most judges do. So like back in the old days, like you kind of had to flip to the last page and be like, oh, what do they do? What do they decide? Now they pretty much put it out there up front. But in terms of, you can tell right away that when the judge was drafting this and he's formulating how I'm going to draft this order up, that he starts building in why he's denying it immediately. So he knew going in as he was writing it clearly that he was going to be denying it. And he jumps right into some of the rationale behind why he did it. Okay, so to ensure that a special motion opponent's own petitioning activity is not infringed by the allowance of a special motion to dismiss, the SJC has adopted a two-stage burden-shifting framework for analyzing the merits of a special motion to dismiss filed under 59H.
So I just want to pause. Sorry, was at the end of that paragraph? Because I didn't want to pause in the middle of the, sorry, finish that.
Okay. So, and then he cites Harborview Hotel to prevent these special motions to dismiss and the powerful procedural protections they afford to litigants from being misused to quell petitioning activity. Our jurisprudence has adopted a necessarily narrow and strict construction of the statute. So that's the end of that sentence if you want to hop in there. Or do you want me to read the whole paragraph?
I think just, yeah, finish the paragraph.
Okay. So a party seeking dismissal under the anti-SLAPP statute must, quote, make a threshold showing through the pleadings and affidavits that the claims against it are, quote, based on the party's petitioning activities alone and have no substantial basis other than or in addition to the petitioning activities. Again, citing Bristol Asphalt. So if the special motion proponent cannot make this threshold showing, which is, again, what Allie was referring to as stage one, the motion is denied and the challenged claim survives. However, if the special motion proponent is able to make the threshold showing, the motion will be allowed unless the moving party demonstrates that the petitioning activity was, quote, devoid of any reasonable factual support or any arguable basis in the law and caused the non-moving party actual injury, such as attorney's fees. So that's the end of that page.
Yeah. So
Okay.
Here's what I want to point out here. So he lays out the two-stage framework. He quotes the Bristol Asphalt and what was that? Allegert, right?
Yeah.
A necessarily narrow and strict construction of the statute. So when you talk about there, notice the tone he's setting. He's quoting the two most defendant unfriendly lines in the case law before he's analyzed a single fact, like the narrow and strict construction employed in a limited context. I mean, nothing's wrong with it. It's accurate, but you can already feel where he's going. He's framing the section 59H as an exception to be like policed, not a protection to be applied. And so you see where he's going with it. And the fact that he's choosing like the most defendant unfriendly lines in the case just kind of gives you his mindset. That's all I wanted to note there.
Okay. All right. Back to the body. All right. So as noted, the defendants have separately filed special motions to dismiss under the anti-SLAPP statute, and therefore they each have the initial burden of showing that the claims against them are based on their petitioning activities alone and have no substantial basis other than or in addition to those petitioning activities. So petitioning activity under 59H includes 1, any written or oral statement made before or submitted to a legislative, executive, or judicial body, which is what we're talking about here, or any other governmental proceeding. Or 2, any written or oral statement made in connection with an issue under consideration or review by a legislative, executive, or judicial body, or any other governmental proceeding. 3, any statement reasonably likely to encourage consideration or review of an issue by a legislative, executive, or judicial body, or any other governmental proceeding. So that's kind of where we're living with both of them here in 3. So, or any statement reasonably likely to enlist public participation in an effort to affect such consideration. That's really where we're living in number 4.
Right.
So, or 5, any other statement falling within constitutional protection of the right to petition the government. So the court concludes that neither defendant has made the threshold showing under the statute. So he's gonna address Aidan's first. So defendant Kearney's initial burden. The plaintiff asserts claims against Kearney for defamation, intentional and negligent infliction of emotional distress, civil conspiracy, and violation of 93A. As explained below, Kearney has failed to satisfy his initial burden for 2 reasons. First, the claims have a substantial basis other than petitioning activity. Second, even if it were not the case, the FAC alleges that he was not engaging in petitioning activity on his own behalf, but rather on the behalf of Reed. So is he a mind reader?
So
is he a mind reader?
So it's good that like you pause there, because that is, first of all, obviously we take issues with whether it's petitioning activity or not, but let's put that one to aside. This second basis that he is relying on is completely unsupported and contradicted by the law. It is clear that you can petition when it's not benefiting yourself. And for him to make this legal conclusion that he was engaging in petitioning activity, not on his own behalf, but rather on behalf of Karen Reed, means, again, he accepted as true the unproven, disputed allegations in the complaint. This is not a 12B6 motion. This is not something that you only look at the complaint. This is, you have to look at both sides. And he put in an affidavit that countered this. So you're not supposed to be resolving questions of fact here. You're just supposed to be looking at the conduct involved and not the intent. And we'll get into it more as he goes through it. But that's one of the very biggest glaring flaws, I think, as to Aidan, just one of them.
Yeah.
That's noteworthy.
I mean, it's significant to pause there because, like I'm saying, what is this guy, a mind reader? Like he's assuming that Aidan didn't mean it.
Right.
Aidan didn't mean it. Like, this is all grift for him. He doesn't give a shit. He's doing Karen's bidding so he can make money and be famous.
Exactly. Which is, he's not allowed to do at this stage 1.
Right. So, all right. Other substantial basis. So Kearney argues that the plaintiff's claims seek to hold him liable for petitioning activity because his statements fall under the 2nd, 3rd, and 4th clauses of 59H. However, he has failed to establish that this is the case. And I thought that Pyle was fabulous in that hearing, frankly. Like, I really did. It was like the stark contrast between the performances of both the attorneys that were arguing their motions was pretty intense in that particular hearing. Pyle came in firing, ready to go, and it didn't seem that way for Karen's attorney. So defamation claim 1. The defamation claim is primarily based on Kearney's repeated statements accusing the plaintiffs of murdering O'Keefe and covering it up. Kearney first argues that that by publicly accusing the plaintiffs of murder, his statements were, quote, reasonably likely to encourage consideration and review of O'Keefe's death by an executive body. However,
he also says it's to enlist the assistance of the public.
100%.
and to comment on a ongoing judicial proceeding, Karen's case. Doesn't have to be his.
Yeah. Yeah. However, all the various places Kearney made these statements on his live stream, social media platforms, his blog, on plaintiffs' voicemails at the plaintiffs' homes, and in the case of McCabe at her daughter's lacrosse game, none were to an executive body as part of a judicial or other proceeding or to any authority that could affect consideration of the issue. Now, I mean, we could debate that until the cows come home. You know, it's that thing where like we've got to have the debate about what petitioning activity is and what are our avenues as citizens to get the government to do something. Like, what is this guy talking about? So I think in Gildea's world, the civil rights movement was all just a fraud because
Right.
what that was just literally people out there petitioning by having marches in order to get the government to pay attention. Like, hey, you know what? We're getting fucked here and we need y'all to do something about it. And we're going to let the cops beat the shit out of us and, you know, blast us with water hoses and have their dogs sick us and all that other shit. I mean, in his world, that's not petitioning activity under what he just put right there.
Right. And I want to find this. Wait, hold on. So shit. Where is it? Where is it? Where is it? Because it goes exactly to your point. Shit, am I wrong?
Take your time, girl. Take your time, girl. You know I can always
talk about it, but I just can't.
No, find it. If it's worth the wait, we'll wait. Yeah, Dr. Joseph. Just to get off while Allie's looking for it. Again, I'm shifting back to Clancy. I'm very Clancy.
Don't do it.
No. Okay. All right. At any rate, I watched it. It was fabulous. I'm working on getting him on the show. He really breaks it down. And also the other thing, thank everyone that has been emailing me who's willing to come onto the show to talk about their personal experiences with mental health issues that they've either suffered personally or with a loved one. We are definitely doing that at some point during the trial in lieu of the judge allowing witnesses to get on the stand in there. I just think it's important for people to hear real people's real stories about it. So,
all right, I can't find the actual case. But there's one that's like one of the watershed cases where it was like Mississippi or somewhere in the South, and everybody went to and protested in front of private businesses that were excluding Black patrons, and the store owners sued, you know, saying that they were interfering with their ability to do business. And they said, no, this is typical. This is anti-SLAPP. It doesn't have to be in front of a courthouse. It doesn't have to be directly to the government. It was like they specifically said this is the way the public, you know, brings awareness to the issues and makes a stand to get the government's attention. So I mean, this has been forever what our federal government has considered to be protected petitioning activity. I mean, a private house is different than a private business. I'll acknowledge that. But the argument the judge is making here, like he's not at a courthouse and he's not at, you know, it's a rolling rally that ended at the police department, you know,
yeah,
too.
100%.
You know, like the fact that it's at a private, it's not on and it also matters like what was he saying right then, but that's long been identified as petitioning activity. And it's like he ignores part of the law when he wants to apply one, like he's staying focused on what was it here that he was saying on, was it 3 as the third, you know, and ignores the whole enlisting the help of the public.
I think he said under 3, 4, and 5.
Right, but then he started to
yeah, really he can't get over
right here. None were to an executive body as part of a judicial or other proceeding or to any authority that could affect consideration of the issue, and it's just not accurate.
It's not accurate. Again, like Martin Luther King's whole thing with the way that, because you have that dichotomy between the way that Martin Luther King thought was the most effective way to petition the government and the way that Malcolm X did it. Malcolm X was force, and Malcolm, he encouraged people to fight back, and Martin Luther King encouraged the folks to just take the beating, because in terms of people viewing it on the nightly news, that was going to enrage them, that watching people being beaten and hosed and attacked by dogs without defending themselves was going to thrust people into action. So you had two very different ways to petition the government, but both of them were petitioning the government. And, here, Gildea cannot move past, move past the rolling rally and the lacrosse game. Like those two events for him, he's never been able to put those aside and look at the bigger picture. Because for him not to realize that when Aidan goes on a live and he's talking to thousands of people on the live, and then another 60, 70,000 that are watching it after the fact, and they're learning things that they didn't know, and they're hearing things that they had never heard, and they're starting to think, well, geez, like what in the hell's going on here? And it spurs them on. And as he continues to do the petitioning activity, it drives itself deeper and deeper into the mindset of the collective public. And we saw the result of it. I mean, there's no disputing, the proof is in the pudding in terms of what happened here. Like you cannot dispute that. But for Aidan Kearney doing what he did in terms of petitioning the government, none of that happens. None of it. We've seen cops lose their jobs that deserve to lose their jobs. We've seen cops retiring. We're going to see Morrissey no longer be the DA. Like if those all are born out of Karen Reed's case, and that's without even getting into Proctor and everything that's going to happen with Proctor. I mean, if you were to follow the timeline backwards, and as we've always stated, Aidan didn't come up with this, third-party culprit defense. It was in a motion that was filed by the defense. It's like anytime I hear people like saying, "Oh, he was working with Karen Reed to create this," I'm like, "What are you talking about?" Lawyers drafted that. Alan Jackson,
Right.
David
Since when can't
drafted that. Go ahead, babe.
No, I'm sorry. I was just going to say, since when can't you rely on an officer of the court's word as a reliable source of information?
And
you tell the court, you tell a court, sorry, you can't rely on an officer of the court's word. Like that's an issue.
Well, what's a bigger issue for me is that what the appearance is that people are allowed to rely on the government's position, because the government always throws their theory out there. In every case you're ever going to watch, in every single case you're ever going to watch, and I've said this a million times about Karen's case and Richard Allen's cases, that, we are accustomed as a country to watching the perp walk when they make an arrest in a case of note. And then we watch the press conference that the prosecutor gives. And then sometimes they'll put a press release out. Sometimes they'll do some more media. But we're hearing the government's narrative, their thought of what happened in the case. And it's nothing more than that. It's a theory. They weren't there. They don't know. They're basing their entire case on their theory. So what they're saying to me is that it's okay for people to be screaming when any defendant is being brought in on a perp walk or heading into court and they're in custody. "You're a murderer." That person's presumed innocent. "You're a child killer. You're a murderer." Like all the things that people scream at people when they've been arrested before they've been tried and convicted. All those, that's okay, because the government said it. But when the defense puts their theory of defense out, as they did here, it's not okay for us to be screaming the same things if we think the defense's theory is correct. It's a problem. It is an absolute problem. And it's one of the reasons Allie and I have a little bit of a debate on this. She likes the concept of being able to keep that back. That's the one thing as defense attorneys that we do not have to tell the government what our theory is. And she likes kind of having that card up her sleeve. Okay. Me, on the other hand, I want the scales of justice going into a trial to be evened out like they were in Karen's case. And that only happened because the defense put out their entire theory. Their third-party culprit defense was laid out for all of us to read, and we all dug into it. And at that point, as citizens, we had a choice. We had a choice to either say, you know what? I think that the defense's theory is the correct theory in this one. Or I think that the state's theory is the correct theory in this one. And you know what? Until trial, we're allowed to do that. But you know what happens when the defense puts their theory out at the same time and they're both out in the public and they're both getting press? Is that people have a divergence in terms of which side they think is correct. So for them to be attacking us and his lawyers, like when I hear the Julie Carpenters, oh, Bob and Alice are talking about the house suspects, you're going to get sued for defamation. Bring it. I have every right to talk about anything that was filed in a public court, especially by a defense team. Bring it. Bring it. Can't wait. I'm here for it. We're here for it. You don't want to pick the fight with us. I'm telling you. So, all right, rant over. Let's keep rolling. Throw it back up.
Okay.
Okay. Let's see. Where was I? Okay. So McCabe and her daughters. Okay. So filing a complaint for an abuse of protection order and the submission of supporting affidavits or petitioning activities, that's citing a case. And then Dever v. Ward, defendant's appeal to the police and to the courts were quintessential petitioning activity. So like you can see he's cherry picking things where people are directly filing things either with the court or with the police department, right? Like in his world, those are the only things that constitute petitioning activity, which, as you can tell, I am not in favor of. I'm calling bullshit on that. So also O'Gara v. St. Germain, reporting suspected criminal activity to the police was petitioning activity. Kearney cites no case law suggesting that statements to other members of the public accusing someone of murder qualify under this case of the anti-SLAPP statute. Such statements lack the supplication to higher authority, characteristic of petitioning activity under this clause. Now, babe, do you want to define supplication for the kids? Allie's like, I thought that was a typo. And I'm like, does that mean like supplementing? Do you remember what the definition was? Are you even paying attention? Is she frozen? Move your finger if you're not frozen. Allie's frozen. All right. Well, she's frozen in a really cute way, but she's definitely frozen. Babe, you're frozen if you can hear me. So Kearney next argues his statements are petitioning activity because they were made in connection with an issue on. Whoa! There's two of you.
What? Yeah, I disappeared.
Yeah, you're there. There was the frozen one, and then there was the new one. That was wild. That was a little. Now that wasn't us. That was definitely StreamYard.
Yeah. So I had to go out and come back in. So did you just get to like such statements lack
the supplication? I was asking if you wanted to tell the kids the definition of supplication.
Yeah, because I'm like, what is this supposed to say? Application? I've never heard of it. So it's basically petitioning, asking for help, begging someone to do something. That's what it is. But that's the perfect place I wanted to stop anyway. Okay. Because the judge is saying, all right, Kearney's statements aren't to an executive body. They weren't part of a proceedings. They weren't to any authority that he could act. So it fails clause 3. Again, he's only focusing here on clause 3 for some reason. He gets clause 4, doesn't ignore it altogether, but not here. So there's contradiction specifically in, and I think he cites the Cardinal Chem case, that's a Huffington Post article that was published to the general public. with only like an implicit call for readers to take action. And they found that it fit squarely, within the statute. No supplication anybody there. So the case he's citing, this Garabedian, is from 2003. The law has changed dramatically since then. The Cardno case I'm talking about is a 2017 case, and it's the Supreme Judicial Court, and the supplication language is being carried forward from like a decision that's not really where things stand right now. So if you sit with that phrase, the supplication to a higher authority, so under that standard, if you go with what this judge is saying, a rally isn't petitioning, a protest isn't petitioning, a document isn't even petitioning, because none of them are a supplication to anyone, a request that someone do something, a begging of someone to do something. You'd have to write a letter to the DA, and that's not the statute. The clause for the enlist the assistance of the public, it exists precisely to cover this like indirect route. I talked to, oh shit, Scout scared me. I talked to the public, and what was I saying? And then the public talks to the government. That's what Cardno is. That was people who were just asking for everyone to pay attention to general environmental issues. So they're pushing the public. They're not the ones petitioning, but they're saying, look at this, what these companies are doing to the environment, pay attention, do something, bringing awareness. It wasn't their own case, all of those things. So that case, they say that a magazine article to strangers on the internet counts. But the judge here cites a 2003 appellate court case that doesn't like even reckon with what happened in 2017. And again, he's applying the supplication to clause 3 only. He takes up clause 4 separately later. So, but he's applies like a clause 1 concept. So let's go back to what each clause is. So clause 1 is statements to a legislative, executive, or judicial body. And he's applying that to a stage 3
which
analysis.
is any statement reasonably likely to encourage consideration or review of an issue by a legislative, executive, or judicial body or other governmental proceeding.
Right. So, and again, he's ignoring the enlisted public for this portion.
Completely ignoring it.
Right.
Pretending like number 4 doesn't exist in the world.
Right. In this analysis, and you can't pick and choose when to apply which one of the, you've got to look at all of them. You've got to look at all of them. And then, no, I forget what I was saying. There was another point.
Oh no. Perimenopause brain. It's reared its ugly head.
I think that's basically it there.
Okay. So Kearney next argues his statements are petitioning activity because they were, quote, made in connection with an issue under consideration or review by a legislative, executive, or judicial body, namely the investigation into O'Keefe's death and the prosecution of Karen Reed. The SJC has stated for statements to qualify under this cause of the anti-SLAPP statute, there must be, quote, a plausible nexus between the statement and the governmental proceeding. And that's Blanchard v. Stewart. And that was overruled on other grounds by Bristol. To assess if this plausible nexus exists, the SJC analyzes objective indicia of a party's intent to influence a governmental proceeding, such as timing, audience, and content of the statement. Okay. Do you have anything to say there, or am I rolling?
I'm going to just keep going.
Okay. The communications must be, quote, closely and rationally related to the governmental proceedings. They were, and made to inform or influence, inform, or at the very least reach governmental bodies. They most definitely were. They most definitely were, either directly or indirectly. I think the fact that Deitch is running for the DA in terms of what his position became during the process of this case, and I'm talking about like in trial 1, like, that is to me one of the strongest components of this in terms of the effect that Aidan had in terms of getting this information out to the public. You know, I mean, it started to reach the upper echelons, and people were starting to notice it in places of power within the government. And they're like, wow, something's going on here, and I got to take a look at it. Or, wow, something's going on here, and I don't agree with what the government's doing. We've got to do something to stop it. You know, I mean, things like that, when you kind of look at it in a broader way, when you're looking at the forest as opposed to individual trees, you begin to see what impact that Aidan's petitioning activity actually had in this particular case. And then, although some of Kearney's statements at least tangentially relate to an issue that was under judicial review, i.e. the prosecution of Karen Reed, the claims largely target statements that do not have a plausible nexus to this prosecution.
All right, so this whole paragraph right here is where like a lot of my issues are. So when you talk about the plausible nexus, he's saying that some statements relate to the prosecution tangentially, but the claims largely target ones that don't. And maybe I should wait till you finish this to get there. But
yeah, let me finish this
Okay.
paragraph and then dig in.
All right.
So the statements are directed toward viewers and potential viewers of Kearney's live stream and the readers of his blog, and their content do not seek to influence government action in any way. And then he says, see Lucy V. Kinnan, which states post not directed to the government and that did not mention any government proceeding, but rather consisted of throwing barbs at another, was not petitioning activity. So rather, the statements are aimed at convincing Kearney's audience to regard and treat the plaintiffs as murderers. So Jennifer McCabe and Brian Albert are involved. They're covering it up. The McCabes have the look of evil in them when you see them in person. These are people with no shame, and they aren't the least bit deterred by the fact that millions of people know that they participated in a murder and a subsequent cover-up of a murder of a Boston police officer. So, and then he goes to a different paragraph. Jen and Matt McCabe do not deserve to live a normal life and pretend that they weren't involved in murdering a Boston police officer. And then in paragraph 90, calling McCabe a cop-killing pig. Such statements, yep.
Before we go into the next step, I want to take over about this case that he cited, this Lucy case. Okay, so here's the thing. Go back up to where he cited Lucy.
There.
All right. So the statements are directed towards viewers and potential viewers of Kearney's live streams and readers of his blog, and their content does not seek to influence the government action in any way. And then he cites this Lucy case, post not directed to government and did not mention any government proceeding, but rather consisted of throwing barbs at another, was not petitioning activity. Now, I think the reason that he chose to cite this Lucy case is because, for example, in this same stream that he's talking about, Aidan had asked for I think he specifically asked like that they seek resignations of the DA and of Norfolk police. I mean, there was tons of absolute positive request for actions. Petitioning activity cannot be denied. So then the question becomes, well, can you, he talked about petitioning activity. It's the same damn life. You know, how can you say that it's not petitioning activity? So that's why he's relying on this Lucy case. And I'm gonna share Lucy, and we're gonna go over that.
I mean, I'll tell you flat out that, you know, in Aaron Spencer's case, when Aaron Casanelli filed the motion to dismiss based on them losing the SD card, which was the most important piece of evidence in that case, and we do a 12-hour live fundraise for Aaron Spencer and his attorney's fees and everything that comes along with that. I have to, like, that was absolutely petitioning the government. You know, I was adamant that the way things everything had lined up in terms of the new judge, Judge Wilson, having everything in front of them in terms of the public support, in terms of you had legislatures that were writing letters on behalf of Aaron, everything that was happening with it. I was directly calling out to Judge Wilson, do the right thing here. Because most of the lawyers, including my wife, were like, well, you know, it's going to go the way that most motions to dismiss go. It's going to be denied. It's an extreme remedy and the most extreme remedy. And I don't think that he's going to end up doing it. And I'm like, it was actually me and Andy Baldwin were the only two lawyers that were like, I think that this thing's lining up perfectly for the judge to knock this thing out of the park and make the big move. And that's exactly what he did. And I have to believe that our coverage on that had some impact. You know, whether or not that's true, I have no clue. Whether or not Judge Wilson.
I say no.
Oh, wow. Well, you always do. You underrate. You underrate.
The judge isn't watching.
You underrate our. How do you know?
All right.
How do you know? Kevin Reddington watches us.
That's true. That's true, but he's not the judge. All right. So were you finished with that, or do you wanted to apply that here?
You bet.
Okay. So here's one of the real important things to note about this Lucy case. So they ultimately found that the statements made on the social media platform about the attorney were not defamatory. So they found the statements did not constitute petitioning activity under the SLAPP statute, but then they also found they were not defamatory. So that just tells you how you could lose on anti-SLAPP and still win on your other motions. But let's talk about, let me see, wait, before I just remove.
What happened to the Westlaw? You froze again. Are you on the Wi-Fi? Oh boy, she's not going to like that frozen picture. She's not going to enjoy that. She is not going to be happy about that. She's definitely not on the Ethernet. That's what's happening there. Yeah, I mean, look, Gildea does not want this case played out on social media. Wait, honey, we're not hearing any of you. You were frozen that entire time.
What is happening?
I think you're getting a shit signal because you're on the Wi-Fi. So we heard none of that. You were frozen, and you
am I still frozen?
You are not frozen now. You would not have been happy with the frozen picture, even though I thought it was terrible.
God, I just want to get off of. I want to turn my camera off.
No way.
All right. So you didn't hear anything about what Lucy's about?
No.
All right. So it's a Facebook thread, same Facebook thread. So kind of like consider it like the same publication, same live stream. And it was in a political group back in 2023.
Hey,
and
Mel. Say hi to Mel.
Hi, Mel.
We love you. Great live yesterday. I got to hang in your chat the whole way. It was fun.
I listened to some of it.
She was sitting right next to me.
All right. I was, but researching, so not hearing except like the occasional. Then he's like, "Hey, you remember when?" But anyway, hi Mel. So you have like this former city council who's criticizing the timing of a zoning hearing, that they're doing it on purpose to so people don't show up. So that was protected petitioning activity. And then the plaintiff, an attorney, replied sarcastically to the post. We'll get into it a little more. And the defendant fires back. Like someone must have taken the bar for you, and some other things. So he sued for defamation. Okay. And the court denied it because they veered off course. So let me bring it back up. All right. So I'm going to go to the places that I highlighted. All right. Well, now that one's just okay. So in 2023, Kinnan, who's the defendant here in the movement on the anti-SLAPP, and Lucy made a total of 4 relevant posts regarding an upcoming public hearing at the city council having to do with the proposed zoning. So he starts out, and I don't even really need to read it. The point is that this first one was completely petitioning activity. So then Lucy, the plaintiff, posts, this is the sarcastic, you'd almost think the original poster was never a city councilor and never took the same summer break, now criticizing, eerie. And now the defendant responds, I'm beginning to wonder if you're capable of reading. You might want to read again. And anybody who would hire you to be their attorney, God bless them, because someone must have taken the bar exam for you. Read below as well for my answer to Mr. Bernstein. It might help you. So first of all, if one of the statements Aidan made here to me was Jennifer McCabe is a pig, a disgusting pig whore. All right. That's completely different than she's a disgusting pig murderer. She's a cop killer. That is completely different than what happened here with Lucy. He's not saying anything about that is related to the petitioning, the topic of the petitioning at all. He's just berating this guy for his, as being a lawyer.
And a shitty one at that.
Right. So, but there's more. Okay. So again, I'm going to ignore it for now, but the defamation case was dismissed, even though the anti-SLAPP was not.
And the reason, again, that Allie's going into this case is because this is the case that the Gildea cited in terms of shooting down that the statements are directed toward viewers and potential viewers of Kearney's live stream and readers of his blog, and their content does not seek to influence government action in any way. And then he uses this from Lucy. He says, post not directed to the government, and that did not mention any government proceeding, but rather consisted of throwing barbs at another, was not petitioning activity. So that's the exercise here. So we're checking his work by going into the cases that he's citing and seeing if he's correct on the proposition that he states that it stands for.
Right. So for the anti-SLAPP analysis, the court here said the motion the judge, the anti-SLAPP motion presents a more substantial question. The motion judge denied the motion, reasoning that Lucy's defamation action was not based solely on petitioning activity. On appeal, the defendant insists that the statement at issue qualifies as petitioning activity, relying on the anti-SLAPP and the express definition. He argues that someone must have taken the bar for you was made in connection with an issue under consideration by a legislative or body or government, and that it was reasonably likely to enlist the public participation in an effort to effect such consideration. The court says it appears to be Keenan's view, the defendant's view, that because he started the chain of posts with a statement directed to an issue before a legislative body, the posts that followed should all be considered as made in connection with his petitioning activity. And again, I just explained why the court here basically found that it doesn't, because they veered off on a completely different topic and just threw unrelated jabs at each other. But there's some other things that they mention in here. And again, this is a 2025 case that are very helpful. So they talk about this about the Bristol Asphalt case, okay, and the Blanchard case, both of which are watershed cases that the courts, mentioned and that they apply to two different statements. There you had like a hospital president who allegedly defamed certain hospital employees who worked there, and the statements they made to the Globe, they said were all right. But then you had this internal email that just went to employees at the hospital and that advised them that, of whatever. And they said that the email one was not, that you can't invoke anti-SLAPP for an email that's just going internally to your employees. But the court held that the statements to the Boston Globe, that was in the same case, were as protected petitioning because the evidence showed those statements were intended to demonstrate the hospital's public commitment to address the underlying problems at the unit. The internal email did not qualify as petitioning activity, however, because nothing in the content of the email suggested any audience for the message other than hospital employees. A private statement to a select group of people, right, does not without more establish a plausible nexus to a government proceeding, which is obviously not what we have here. and there's some more language in this case that's going to touch on that as well. So, and this is it here. Okay. And again, in this case, like they argued that this was all in an effort to influence the city council regarding an upcoming hearing. But again, whether this guy is a bad lawyer or not has no bearing on that. So then they cite to this McDonald case. Okay. The decision in McDonald on which Keenan relies is not to the contrary. In McDonald, a plaintiff, a town selectman, and retired police officer brought a defamatory action after the defendant characterized the plaintiff as acting like a Nazi on the defendant's website. And it doesn't really matter about any of this. It's this last sentence. This court held that the plaintiff's defamation claim was properly dismissed under the anti-SLAPP statute, noting the defendant's description of her website as a technological version of a meeting of citizens on the town green.
Strong language.
Right. And you can't
And
tell
that's a
me,
website.
right.
That's a comment on a website.
Right. Now, the website was geared towards, local government, but at this point, Aidan's platform was geared to government corruption in the police force. What's going, and it wasn't just Karen. And the judge just completely dismisses that when it does speak to whether he was speaking for himself, which we're going to get into next.
Well, plus the comments to the Boston Globe. Like, I mean, what is the difference between the Boston Globe and, Aidan's blogs, which I hate that word. I don't even know what that word means, but the guy wrote 500 plus articles. And if you can stomach his website that has so many ads that I hate, these are actual well-researched articles that are going into, things that he's investigated heavily. And I fail to see any difference from things that he's writing on his website, in his blogs, or in his articles that differentiate it from the Boston Globe and or Boston Magazine, whatever the case may be. It's like he's just ignoring that, and you have to wonder why. It's that thing where you get the feeling that the guy's biased, and then when you see him apply the law and cherry pick it in such a way that it becomes evident that he's already in his mind, and even though he's not the trier of fact here, he's made his decisions on this case. Like he does not like Aidan Kearney. Like, that's clear. He does not like the way that he speaks to people, any of that. So he's made a decision, which to me, when that creates an actual bias in terms of how he's going to rule on things, they got to make the move. I think they have to make the move to recuse him. Like he lays himself out, and I'm not as much concerned about kind of his snarky orders that he's written in the O'Keefe matter, wherein, he's clearly appearing to be very biased there as well. When it comes to like a totality of the circumstances, and it becomes evident that he himself has formed an opinion as to Karen Reed and what happened in that trial and whether or not these folks had anything to do with it, he very much seems to be a person that has reached a conclusion on his own. And that's bleeding into his decisions. And he is supposed to be an objective person sitting up on that bench. I mean, it's his role. Objectivity is a necessity as a judge. And he does not seem to have that objectivity. And when he's, again, cherry picking language the way that lawyers do. I mean, that's what lawyers do, is we pick language from decisions that help forward our position. And that's not to say that judges won't do it, but they can't do it in such a way that they're ignoring other parts of that same decision that aren't necessarily dicta, and he's just pretending like they don't exist. It's, I don't know, man. I think that he's not going to recuse himself. That's not going to happen. There's going to have to be a motion filed. And whether or not they're going to be up for that challenge. Because the risk in that, and I think I'm 99% certain, because we saw it with Canoni when Karen's team tried to get her removed for being biased. The judges are sitting on their own bias hearings, which is the most ridiculous proposition. I can't fathom whoever drew up the laws thinking that was a thing that judges are capable of doing, like being honest about whether or not they're biased. I mean, judges aren't going to be like, yeah, I'm biased as hell. Like they're never going to admit that. You have to have another judge sitting on that and have the judge presented with the facts and the arguments supporting, what you're claiming in terms of bias, and let that judge decide. And that's still, if it's a judge within the same building, judges talk, judges are buddies. It's like, it almost has to be a special judge that's assigned, that's not in that building, that has no connection and doesn't have, their offices 2 doors down from the other judge, and has to go in and work with them every day. Like, oh yeah, you're like, nice. You said I was biased. Thanks, pal. It's like you have that unspoken pressure, if it's judges in the same building. So, all that to be said, that Gildea would be sitting on his own hearing, and ultimately Gildea is not going to sit there and say, yeah, I'm biased. You can say that's a load of shit. I'm not biased. I just don't think the law supports your position. So it's not as easy as people think to get rid of a judge. It's very tough, actually. Sometimes you got to go up. You got to go up to the Supreme Court of the state in order to get it done. So, all right. Are we continuing to read, or you have more?
I just want to round that out by saying that, like, again, if you think about it, the bar exam insult in Lucy, had nothing to do, like we said, with the zoning hearing. So that really was a veer. A rude post about zoning would have still been protected. A polite post about the guy's bar exam wouldn't have been. So when you apply that here again, cop killing pig, is that a veer off topic? No, strip the vulgarity out, and what's left is Jennifer McCabe killed a police officer. And that's the exact proposition that Aidan was demanding the Norfolk DA investigate.
Right.
Like the insult and the petition are the same sentence. So, again, here's the test. If he had called her a pig whore, that's Lucy. If he had called her a dirty homeless slob, that's Lucy. Neither of those say anything about John O'Keefe, police misconduct. Did someone murder someone? Is somebody covering up something? Is someone not investigating something? But a cop killer, that's that. Yeah. Is there an insult? It isn't an insult instead of the accusation. It's the accusation, said in a way the judge doesn't like, but it's still the topic. And at some point, like going back to that McDonald case that they cited in Lucy, speech is vulgar, speech is protected. Like the official conduct at issue is protected, then it doesn't matter how horrible it is. And they've got like another case from 2023 where they like civility cannot be required, and that Article 19 expressly envisions a politically active and engaged, even aggrieved and angry populace, so they're not expecting niceties, which is what it seems like this judge is relying on. So Lucy cuts, against the argument that, well, he said it all in the same lie because it was all in the same post. And again, that's why I think he really does it. So it proves that the judge is allowed to sever statements inside the single conversation. And that's the judge is citing it because the defense is like, look at the campaign as a whole. It doesn't change that you still have to look at the campaign as a whole. I mean, again, these statements were like, had nothing to do with anything. So the judge's method of like, I can take out a statement that's in the same lie where there's a call to action. He's correct. He can. And Lucy supports that. but it's not over whether he can sever it. It's whether the particular statements are severable. And a cop killing pig, you know, isn't. It's not severable.
Yeah, and I'm going to hearken you back to my rant about the fact that a motion was filed in this case wherein the defense outlined in great detail why they believe that the people inside that house were the actual people that committed the crime. This isn't a situation where Aidan or anybody else was out there running and screaming that a random person that had nothing to do, that wasn't in that house, that had nothing to do with John O'Keefe, that, you know, that you're calling that person a murderer with no basis in fact and no evidence to support what you're saying is true. This isn't that. This is not that situation. Again, the existence of that motion and it laying out their case against the people inside that house in terms of what their theory was created a situation wherein the petitioning activity was for two reasons. It was one, to drop the case against Karen because they have the wrong person. And two is to do an actual investigation into the people inside of that home and of the home itself. That's what the petitioning was about. Now, we can argue all day about whether or not every single thing that he did in terms of trying to accomplish that was effective, but that was always the motive. That was always the motive. The motive was to incite the public so that the outcry was so loud that it could not be ignored by the government, period. And, you know, why Byeeeee? It's because he was just screaming at civilians, not protesting the government. I disagree. I disagree. Part of getting the public behind what you're saying is, number one, informing them of the issue and informing them as to why you believe that that person may be a person that needs to be investigated instead of the person who's been charged. And in order to do that, you might have to scream at some civilians in order to be able to get the public behind what you're trying to accomplish at large. Because what wasn't available to Aidan Kearney or the public at large in this case is going to the very agencies and complaining to them when they're the ones who are already moving forward on convicting Karen Reed. Talking about falling on deaf ears, I can't think of a situation. And beyond that, what's even worse is that you're talking about that department or the MSP, both of those agencies being corrupt. So are you suggesting that the move, if you're Judge Gildea, is to go to the two agencies that you're screaming are corrupt and file some kind of complaint with them? That's pointless. That's just screaming into the void. That's going to have zero effect. They were trying to get other agencies to look at this beyond MSP in Canton. They couldn't be the ones because they were complicit in the eyes of the defense, in the eyes of Aidan, in the eyes of all the citizens that grew to believe that the defense's position in this case was the correct one. So petitioning to those agencies would have zero effect. So it becomes a much more difficult task for the petitioner to figure out, all right, well, you know, who am I screaming to here? Or do I just have to scream to the world at large and hope that somebody that matters in a position that can do something hears me? And that's where we're at with this thing. Like, that's what was going on.
Preach.
All right, pull the doc up so I can continue to read.
Oh, I forgot I took it down.
Yeah, keep going. All right.
And we're stopping after this next one too. So
okay, so we ended with the throwing barbs thing. All right, so
no, you were on page 5.
Yeah. So, right, but I was trying to remember what sentence. So Jennifer McCabe and Brian Albert are involved. They're covering it up. The McCabes have the look of evil in them. And when you see them in person, these are people with no shame. Yeah, I think I read this. And they aren't the least bit deterred by the fact that millions of people know that they participated in a murder and a subsequent cover-up of a murder of a Boston police officer. Jen and Matt McCabe do not deserve to live a normal life and pretend that they weren't involved in murdering a Boston cop. And then on paragraph 90, calling McCabe a cop-killing pig, such statements are markedly different than those that courts have concluded are made in connection with a proceeding under judicial or executive review. So, and then he cites Kriegel, statements to media by a firefighter's widow were sufficiently tied to and an advancement of her petition for benefits under consideration by the legislature and were mirror images of what she had reported to the governmental body. Okay, the FAC also cites allegedly defamatory statements Kearney made after the second trial had ended and therefore not connected to any issue under judicial review. He's lost the plot.
He sure has.
Again, there were two parts of it. One, dismiss the case against Karen, and two, investigate into the people in that house. Because short of some complete freak accident where John slipped and cracked his head, my third theory, which people hate, which I love it so much. You know, it's either one or the other. And if you believe in science, if science matters to you, then you can't walk away from what was introduced at trial 2, believing that John O'Keefe was struck by a motor vehicle. You can't. You know, I don't like it. Whatever bullshit the other side says, the science speaks to me in a way that is incredibly convincing. On top of the fact that when I look at the injuries, they just are not indicative of a person who got hit by a 7,000-pound vehicle, period. End of conversation. Like, no one's ever convincing me that otherwise. And that's that. So if that didn't happen, in my little scenario, which I think is a possibility it didn't happen, that leaves one possibility. And so whether or not the case against Karen is over, there's one missing element that the judge doesn't seem to care about, is that there's no justice for John O'Keefe. And this thing's going to just die in the water. And I don't think anybody wants that, right? I think that there's still a pretty heavy-duty movement. I mean, Karen has said publicly that her entire incentive in terms of filing against certain parties is to get justice for John O'Keefe. That they want this played out in the public on a civil stage in order to dig into these folks a bit more than they were able to in the criminal trial. So to me, you can't say if Karen said that publicly and then she followed it up with the lawsuits, that's certainly petitioning activity. Right? And you can't separate what's going on after the fact in terms of people that are still demanding justice for John O'Keefe, that still believe that those folks in that house had a hand in John O'Keefe's death, demanding action by the government. I don't see how he's missing that. Again, that's where I'm saying, when you're reading his opinion and his ruling here, you can't help but think that he's reached a conclusion on his own in terms of what may or may not have happened that night. And it's not proper. That's not what his role is. Again, he's not the fact finder here in terms of the trial in and of itself. He can't be the one deciding, well, I think that's bullshit. So, like, he's got to make a legal analysis in terms of what the case law is and figure out if these things fit in a certain way. Now, when we get to what the next step is here, we'll get into this conversation a little bit deeper in terms of, you know, what's going to have to be argued. I think it's, you know, Pyle did a fabulous job. He really did. But, you know, he was limited, and that was a hot bench. You know, Gildea had very specific questions he wanted answered. So it wasn't as if Pyle got to go in there and speak his mind and make his arguments. He didn't get to flesh out a lot of things because the judge, as I said, was a hot bench, and it was more like an appellate bench where the appellate court judges come out and they have very specific questions that they want answered by the attorneys, and they hammer them right away. You know, so it's like you're taking off your script if you have one, and you're having to try to answer the questions that the judge has to the best of your ability. So wherein you're not getting to be able to argue the things in terms of why this constitutes petitioning activity, Judge. Like you're missing the plot here. You know, I need to make my argument. I want it on the record as to why I believe that this constitutes, because you're stopping your analysis short of where it goes. So, all right, did you want me to keep reading, or was that did you want me to get to the end of this particular section, like the finally part?
All right, let me see where we're.
So
No,
I
want you to just keep going, because we're going to just, that he brings global naps up again, and then we'll go over it when we hit it again.
Okay, so the FAC also cites allegedly defamatory statements Kearney made after the second trial had ended, and therefore not connected to any issue under judicial review.
Again,
So,
just ignores all the other prongs. Like, that's not the only one. That's not the one he's relying on.
yeah, I mean, right. So, and then he cites another case and settlement demand made to resolve disputed issue under review by planning board was made in connection with a pending governmental proceeding. So that Kearney's statements concern a topic that has attracted governmental attention in itself does not give them the character contemplated by the statute. And then he cites global naps. And then finally, Kearney relies heavily on his argument that his statements were, quote, reasonably likely to enlist public participation in an effort to affect consideration by an executive or judicial body. In his motion, he cites multiple instances where he both engaged or encouraged people to demand answers from the MSP and the Norfolk District Attorney's Office, and encouraged his audience to engage in standouts and to gather at the courthouse in protest of the prosecution. So footnote 4 is, to the extent that Kearney contends that his post-verdict statements were likely to encourage review by law enforcement into those responsible for O'Keefe's death, allegations in the FAC belie his claim. What? For instance, the FAC cites Kearney's communication to his followers to use a, quote, code for the McAlberts killed John O'Keefe. FAC at paragraph 14. It's strange credulity to argue that such a statement. Oh, boy. It's strange credulity to argue that such a statement, which obscures the message so only his followers can understand it, could reasonably be interpreted as made to influence, inform, or reach governmental bodies. He's not taking into consideration Aidan's reach. Aidan doesn't have,
absolutely not.
Like his reach is what matters. Aidan's got a pretty long reach in terms of his followers and the people that watch his show.
What did we just read from Lucy? It was technological version of a meeting of citizens on the town green.
Exactly.
Period. Done. Point. The end.
Yep.
Read the cases you cite, Your Honor. Is he SLAPP happy?
I mean, seems like it. So the FAC also alleges that Kearney posted a video encouraging his followers to attend and protest a fundraiser hosted by a supporter of the plaintiffs, asserting that it was being held for, quote, the people that framed Karen Reed for murder and that killed John O'Keefe. It is unclear how encouraging his followers to attend a private event would reasonably likely encourage review of O'Keefe's death by an executive body. Man, this dude, wow. All right, so while the court agrees with Kearney that such conduct constitutes petitioning activity, his argument that the statements cited in the FAC are related to his conduct and therefore should be viewed similarly is without merit.
And again, he cites to Lucy.
Cites Lucy.
And he says, the fact that the defendant's initial post constituted petitioning activity did not then throw an anti-SLAPP protective blanket over every post that followed. And we've already showed how he is comparing apples and oranges. Again, that's the whole jab about this guy being a lawyer, not having anything to do with what the petitioning activity in the post. So, yeah. Go ahead, babe.
Oh, sorry. Okay. So the fact that the defendant's initial post constituted petitioning activity did not then throw an anti-SLAPP protective blanket over every post that followed. The defamation claim is not aimed at the specific instances that Kearney cites in his motion. Rather, the claim encompasses statements that are far removed from any call to the public to appeal to the government, namely the many instances where Kearney accused the plaintiffs of murdering O'Keefe and covering up their crime by addressing them directly at their house via his live streams, or in the case of McCabe at her daughter's lacrosse game. In those statements, Kearney neither explicitly nor implicitly calls on his audience to implore anything to a governmental body. And then he goes to footnote 5. For instance, Kearney does not explain how his enlistment of 200 individuals to participate in a rolling rally to go at the plaintiff's homes while he shouted into a bullhorn that Brian Albert and McCabe were covering up John O'Keefe's murder was reasonably likely to enlist public participation in an effort to effect consideration by an executive or judicial body. Nor does he address how going to McCabe's daughter's lacrosse game and calling her a cop killer was likely to do so. And then he cites a case. Saley v. Armstrong. Right. So although neighbors' opposition to home renovation before town boards was protected, a threat made as the neighbors were leaving a hearing before the board was not protected. This is completely different from that.
Exactly. I don't even need to pull up the case. We can all see it's completely different.
Completely different. The point in screaming at the McCabes on a live is to, again, enlist the public to believe that what he is saying is true about them in order to get them on board. He's asking them questions, and they're direct, hard, ugly questions to be asked in public. There's no question about that. However, is it a fair question to ask? I mean, you hear reporters screaming at people that have been arrested constantly. Did you do it? Why'd you do it? Why'd you do it? It's the same shit. There's absolutely no difference. There's absolutely no difference in any other situation wherein people have bought what they have been sold by the government in terms of when they've charged somebody, and many times they get it right. So it's not without cause that people have a tendency to believe when they make an arrest that the government has got it right, but they don't always get it right. And therein lies the rub. And so when, you have those cases again, when people are screaming at people that have been arrested who are presumed innocent, why'd you do it? Well, why'd you murder them? Why did you do this? Why'd you do that? It's the same exact shit. And when it's being broadcast to people that could go out and form coalitions and draw up signs and stand out there and picket and do all those types of things, that's exactly what it is. I mean, it goes to the heart of what petitioning activity is. I mean, us as citizens, we're somewhat limited. And it can't be, I have to write a strongly worded letter to a government is all that encompasses petitioning activity. That can't be it. Again, think about the civil rights movement. Think about what that looked like. Think about what people were doing. I mean, do you consider that to be petitioning activity? Of course, obviously.
Right.
And 99.9% of the people that were out there in support, they weren't writing strongly worded letters to the government. They were out there with a show of support en masse to let the government know this shit cannot stand anymore. That us, the citizens, will not have it. And this was the same thing on a micro level. It just was. And it just happened to be about one case revolving around one cop that lost his life. It's no different. It's just a different sized petitioning activity. That's all. All right. Okay, so
Wait, so before we go on from there, I want to bring up, so actually, let's put it back up and then go up back to global, because I forgot to pause you there, and footnote
was
4.
global the footnote?
No,
Yeah.
but it covers footnote 4. So just keep going up.
Okay.
All
There it
right.
is.
So this is where he's saying go up a little bit more.
Go up a little more.
Yeah. All right. So he's talking about how they're made these defamatory statements after the second trial had ended, and therefore are not connected to any issue under judicial review. Again, the judge, as Bob said, cherry picking when to apply which of the, the 5 categories here. He's just ignoring the fact that he is the category 3. So he's dealing with 1, statements statements in connection with an issue under review of a party, but not statements that are reasonably likely to encourage consideration or review by such body. Again, still, obviously, we all know this, still asking for them to investigate the right people, charge the right people. But he goes on to cite, he say that Kearney's statements concern a topic that has attracted government attention in and of itself does not give them the character contemplated by statute. And before that, he cited this global NAS case for the proposition that, I'm just going to find it over here, not make you.
I don't mind. Is it up or down?
It should be earlier.
A little earlier.
Let me see where it is.
Is it related? Is it naps specifically?
Yeah.
I thought that was the first
Maybe
time
that was
cited.
it.
That was it.
Okay. All right. So, all right. So we're going to pull up. Okay. They cite it again later, but we're going to pull it up now. So let me share my screen. All right. So global naps. And again, this is a 2005 case that, if you can see here, is like questioned authority, overruling risk. But, typically you can still cite to some parts of.
Allie was pointed to the yellow flag.
And then the exclamation point next to it.
Yeah. So, and they call this shepherdizing. So when you look at cases, first thing that you have to do, it's one of the things that AI, aside from completely hallucinating cases out of thin air, it's not real good at shepherdizing cases and making sure it's still good law. Because what happens, and this is going to be very short, babe, what happens is the law changes. It's ever evolving, the law. And sometimes decisions are overruled. Other courts within the same circuit or district will say, you know what? I know what that court said, but we feel differently about it, and the law will change. So you got to look. If there's a red flag up there instead of a yellow flag, it's bad law. Law's changed.
Right. And here's where it says it's been called into doubt by that Blanchard case that the judge cites a lot. And the overruling risk, it doesn't have to do with what this judge is citing, but still, it's an application of old law nonetheless. Okay. And in this case, all right, the center of the action is a clash between telecommunication providers. So competing companies. And they brought, the plaintiff brought 2 arbitration cases against the defendant, which were resolved in Verizon's favor. And then subsequent to those, one had already been appealed to the regulatory affairs, and they gave an interview to the Boston Globe. And the reporter quoted him as having said that the arbitrator's decision was essentially a shutdown of a scam that Global very cleverly had developed in the late 1990s. Okay, so as background, that says that they're contending that the statements were made in connection with Global's pending appeal of the arbitrator's decision. And the court here concluded the statement does not fall within the ambit of the statute's protection because it was merely an oblique reference to Verizon's petitioning activity and was not a protected instance of full participation and robust discussion of issues before a governmental body. And again, that's the one at issue in here. So that's the one Global's discussing. Again, our judge is ignoring that Aidan's relying on more than that here. So And here there was a robust discussion of issues before a government body. There's no fucking question about that. So the court said, to place the issue in context, we summarize the undisputed facts. The statement upon which Global bases its defamation action was made within the context of a larger business dispute. Global and Verizon provided telecommunications services in Massachusetts. The two companies were competing, blah, blah, blah. And the telecommunication networks had entered into an interconnection agreement. So essentially, as competitors in a regulatory industry, the two companies frequently, if not constantly, involved in proceedings before courts and other governmental entities. So when we get down to here, the article at issue, they said that Jack Conroy, Verizon's, the article then summarized the quoted conversation between the reporter and Conroy, which became the focus of Global's defamation claim. Jack Conroy, Verizon's Massachusetts regulatory affairs chief, said the DTE ruling shut down a scam. He said that Global NAP very cleverly developed, and he flushes it out. The court said the burdens on Verizon, the moving party, so here the should have been House suspects, to make a threshold showing that the activity at issue is petitioning activity. In support of its motion, Verizon furnished affidavits and pleadings to the motion judge indicating that Conroy's comment was made, quote, in connection with a matter under review by DTE and the courts, and thus constituted petitioning activity as defined by the anti-SLAPP. The judge rejected this contention. We're gonna get to that, but also remember, we just read a 2025 case that the judge cited, Lucy, that explained that under consideration is applicable in when you're dealing with 3 and 4, or as far as the 5 reasons. So when you're dealing with the statements in connection with an issue under consideration, statements reasonably likely to encourage consideration, and statements reasonably likely to enlist the public. It gets limited in ways that this judge is just not applying. So let's look at this footnote 4 because it's really, really important. Why won't it let me go down to it? Wait. Okay. So the court said here, although we agree with the judge's conclusion that Conroy's comments did not constitute petitioning activity as contemplated by the statute, we reach our conclusion for different reasons. The judge based her decision in part on the view that the only party that exercised the right of petition to seek protection of its rights in this matter was Global, as it was that party that initiated the arbitration proceedings and appealed the results of the arbitration. We question this portion of the Superior Court's decision limiting the protections of the anti-SLAPP statute to those parties who first bring a dispute to the attention of the government or seek some adjudicatory body resolve a claim. That's exactly what the judge is doing here, where he says, well, he was just working on behalf of Karen. He wasn't doing this on behalf of himself. Like, read the cases you cite. The court here specifically questioned that, like, no. What you did is wrong. And we're going to do it. We're going to do it differently. And they even quote this Corbin case, and it's back also from 2005, and also the Wynn case that this order cites all this stuff. There is no statutory requirement that petitioning parties directly commence or initiate proceedings. So what are we doing, Judge? What are we doing? So back, go ahead.
Attorneys Pyle and Seligson, if you're having any thoughts about appealing, you might want to throw that footy in there. Oh, she froze again. She gone. Babe, you're frozen. If you can hear me, your face is frozen. She looks intense in that one. Yeah, she's gone. All right. Let me see. I'll throw the document back up. We'll read until she gets back. I hope you guys are enjoying all of Allison's very, very hard work. Like, I'm not kidding. From the point where I was listening to Mel's live yesterday, sitting right next to her, she's been researching all night up until 10 minutes before this live. She was researching. I was watching reruns of The Amazing Race. Allie was back on the bed researching. I had to yell at her, quit researching. We have to go live. We were 10 minutes late. Why do you keep freezing, babe?
I have no idea. I have no idea. But the last part, I don't need to put it up for this. It goes directly with this reading of the in connection with narrowly. Okay. And it says the statute enumerates, and I said this was Lucy, but it's actually from here. The statute enumerates no fewer than 5 types of statements that compromise petitioning. Verizon focuses exclusively on the second category. And again, the second category is statements in connection with an issue under consideration. And asks us to read it broadly and in isolation, paying attention to the context. Paying attention to the context compels the conclusion that the sweep of in connection with is limited because the phrase pertains to statements made to influence, inform, or at the very least reach government bodies, either directly or indirectly. Goes on to say specifically the first, third, and fourth phases. So now we're covering exactly the enlisting the help and getting it in front of the review and end one that's already in review. Support reading in connection with as embodying to some extent similar purposeful elements. And they're saying that, so literally when you read this, it takes this in connection with and puts it in our case to say that it needs to be read more broadly than they did in global, because they weren't applying it to any of those, any of the same phases or the 5, options. So as we read it to indicate that the 4th specific item listed are meant to illustrate not an exclusive list, okay, sorry, that part wasn't important. So anyway, taking this end, Lucy also did mention this because that was the whole thing about it was in connection with, because it was part of the same thing. And we're like, well, we can't read it that broadly because you just talked about some shit that had nothing to do with it. But even in this case that he is citing to, they're saying context compels a different conclusion. In global, this was really a dispute between 2 competitors. And then he just tried to kind of loosely tie it to, oh, I got this appeal pending. Now, that's not really what you were even talking about. So, overall, the judge is citing cases that when you read other parts of it, contradict him in very significant ways and don't stand for the proposition as he is applying it. And again, we all know when you're talking about the whole after versus before, come on. He's answering a question that he didn't ask. The judge is answering a question that Aidan didn't ask. He didn't say that this was to do with petitioning in front of that aspect was to petition the court about a case currently under review, which, by the way, was still under review. He specifically says it's, even if that gets resolved, it's to continue opening up or continuing an investigation, starting an investigation, all the things that we all know. It's obvious that this judge is just being dense on purpose. And I really hope this comes back.
And incredibly biased. Gildea knows he's on both cases. He's on the O'Keefe case. He's on what does he think the heart of those cases are? The entire case from Reed's position in the O'Keefe case and Kearney and Reed in the defamation case is going to be putting the House defendants on trial. Why is he acting like anything that's happening now is still not? They're petitioning now a governmental body being the judge to dismiss this shit. They're out there trying to raise money, and this is what we believe they are. It all goes to the same place. The litigation is still continuing. It may not be in the criminal venue, but it's in the civil venue. And again, Karen Reed has been very, very consistent with her messaging in terms of why she felt it was necessary to file suits. And that's because she has every intention on proving, and at a much lower burden, mind you, that it was the folks inside that house that are responsible for John O'Keefe's death. That's it. I mean, she wants some kind of end result to happen on behalf of John O'Keefe. And this is the last avenue available, because clearly law enforcement's not going to do anything about it. So this is it. This is all you got. It's like when the Goldmans and Nicole Smith Brown, they sued OJ after he was acquitted. They wanted some form of justice. They wanted an acknowledgement by a court and by a jury, and for the public to see, all right, well, you may have slipped out on the criminal case, but they found that you were responsible for her death. You're liable for her death and Ron Goldman's death in the OJ case. And they were able to walk out. If you ever watch the interview of Ron Goldman's father, like weeping after they got that decision in the civil case against OJ, I mean, it meant something to him. And it wasn't about the money. It was about hearing somebody utter, yeah, we find that he is responsible for their deaths. That mattered to him. All right.
Well, before we go on, I would just want to talk about what he also said, because we covered a lot of things in those 2 pages.
Okay.
So he was also talking about how, none of this matters about the post, post-trial, post-acquittal, post-first trial statements. And he claims that like the post-acquittal speech cannot be petitioning activity because the criminal window trial was closed. But you have multi-objective petitioning matrix. Like we talked about that with Karen Reed, that I thought that they failed to give other objectives. You can have multi-objectives to your petitioning activity, and it needs to change depending on where you are at time. Like here, the plaintiffs argued and the judge bought that the FBI probe was strictly a narrow review of police procedures. So accusing the private house witnesses of murder fell outside of that scope. But the legal reality is only the state has jurisdiction to prosecute homicide. And they could also ask the FBI to expand their investigation, expedite their investigation, and again, compel the state to do something. The FBI can't indict someone for a Massachusetts state murder. So therefore, to get a genuine, uncompromised investigation into the murder of Officer John O'Keefe, the public had to target the state leadership and the mayor, the attorney general, the state command by continuing, as Aidan did, to publish his Canton cover-up series post-acquittal, naming alternative suspects. They both were engaging in continuous protected effort to force state leadership to launch an investigation. And demanding that a state investigate is textbook petitioning activity. I think the case is arsenal, and we don't need to get into it, but it covers the entire post-trial timeline. And I think the defense hopefully can hammer that home even more in their appeal. But the whole rolling rally, bullhorn, lacrosse game, the judge is saying he agrees that the standouts at the courthouse, the protests are all petitioning activities. But then he says the accusatory statements aren't covered by that. And that gets us to that footnote 5. Kearney never explains how the rolling rally of the plaintiff's home with a bullhorn or at lacrosse game enlists public participation. Well, first of all, I still say you've got the whole local citizens there at that game. So it's right in front of the public. But he also says simply filming his actions and posting them later does not bring such conduct under the protections.
Bullshit. It keeps applying the pressure.
He didn't cite anything, babe. There's no case cited for it. The judge just fucking says it.
I know.
Right.
I've made the case for that. It's all petitioning activity. It just is. At YBE, it's I love you, girl. I know you can't stand Aidan. You're the same as Gildea on this because you can't be objective. It's you allow your hatred of Aidan personally to cloud your ability to be subjective. And the reality of this situation is you can hate the words that he uses. You can even hate the fashion that he does things. But the fact of the matter is when he's getting the message out, and the message has never changed. The message has always been, why aren't the cops looking into these people? These are the people that did it. Why aren't the cops looking into these people? Why aren't they being investigated? They're the ones responsible. Why isn't that happening? Pressure makes diamonds. That's it. And, you know, in order to keep the public fired up, you're going to have to do things. They're going to be in people's faces that are uncomfortable. You know, I mean, it's like, if you ever look at old-fashioned, old-timey investigative reporting, I mean, back in the day, reporters would go at people. And that was when the Fourth Estate meant something, and it doesn't mean anything anymore. And it's a huge gap. We need it. Like, investigative journalists are what keep the government and its people that work within it honest. If they're allowed to creep around in the shadows with nobody asking questions, we're fucked. It's that simple. So, all right, let me pull it up.
Wait, hold on. So,
all right, I can tell you right now, I'm starting to think of that lobster truck that's right.
I know you are.
North
I just want to
Aurora.
say, I just need to say here,
I'm
like,
hungry.
again, when we go to how he is citing, you know, things that for one reason, when they can be literally applied the other way. Again, Lucy's structurally different, but you've got, you know, one of the cases he cited is that how statements are assessed in the overall context in which they are made. And when you apply that here, you know, as again, an easy comparison is that Lucy case. This is a broader campaign. It's like the Cardno, the environmentalists campaign, where the SJC said the defendant's broader campaign, marching to Washington, press release, meeting with officials, like that was the context of the whole thing. And that's why this is very different than how he keeps trying to pigeonhole it and like just pull something out like they did in Lucy, where it could be pulled out. And here it can't be pulled out. You cannot say, as we all know, and as Aidan's lawyers argued, you cannot say the police are failing to investigate a crime without saying, here's the crime and who committed it. They're inextricably intertwined, period, the end. You know, and when you look at the pleadings themselves, they you know, they do talk about that there was like a select board dimension. I think it's in a footnote, you know, that posting about citizens revolting at the select board meeting. You know, so it's like the judges using cases that apply differently here to try and like make something fit that doesn't fit. That's the way I see it. And then he says the filming doesn't launder it. And honestly, there is like a case that says, you know, opposition before a town board is protected, but a threat, and that was the thing that he was relying on, made to neighbors walking out is not, and a camera wouldn't change that. That's not what it is. It's not like, it's not just we filmed it. It's the broadcast was the point. It was a performance for the audience being asked to act. Like just one like threat walking out of a hearing, you can't make it petitioning activity just because you put it on a camera. But that's not what happened here. That it's clearly not what happened here. The whole thing is that it's on camera. I mean, the lacrosse game, you know, might not change. I don't think it changes the anti-SLAPP, but it might change some of the other, you know, the other counts. But, you know.
Yeah. Yeah.
All right.
All right. Can I pull it up?
Yeah.
All right. Back to the body, as my wife likes to say. So to be sure, the FAC cites many statements that were reasonably likely to enlist Kearney's audience to share his opinions and to make that point known to the plaintiffs and other members of the public. And then he cites paragraph 90, citing Kearney's statement that he has nothing but hatred to McCabe, as I should, because I'm normal. I'm a rational person. Any rational person hates Jennifer McCabe and is disgusted by her because Jennifer McCabe is a pig. She's a pig. She's a cop killing pig.
There you go. It's back into the petitioning activity. He's not just saying the words. It's all tied to she murdered a cop. They're not investigating it. They're covering it up.
So responding to McCabe's friend that she was harassed by Kearney, supporter in public, Kearney stated, quote, "The fact that Jennifer McCabe has to cover her face in public like this because everywhere she goes, immediately people see her face and recognize her as a cop killer is a great thing."
Yes, it is. You know why? Because that means the message is getting out there that the petitioning activity is working. This is just not you've got this old judge who's like, I don't like the way he treated these people. But that's not the fucking question before you at stage one. It's not. The question before him is this petitioning activity and everything that he is citing to the judge, it doesn't stand for the proposition. Look, I'm probably overstating my hand because I'm just passionate about this, and we'll hear when it goes to an appeal. So I'm not like, hey, I'm absolutely right, but this is the way I fucking feel. And I hope that the Supreme Court gives some pushback because there are absolute flaws with him looking at intent, deciding issues that don't get decided on phase one. Obviously, the court can come down for other reasons, like we just read in the Global case. He's like, well, the Superior Court made the wrong decision, but here's how we can make the same decision right. But not the way this judge is doing it, not the way this lawyer interprets it.
Yeah, you convinced me, babe. I'm with you, honey. All right. So where was I?
You're down.
Okay.
On 8.
Okay. So alleging that no, I'm not that far down.
Oh.
I don't think. Okay, yeah. No, alleging that Kearney addressed his audience members who had not confronting the plaintiff, stating, quote, "They're right fucking there walking around like nothing happened. What are you going to do about it, huh? You going to ask them anything? You going to talk to them? You're not in this. You're not in this for being uncomfortable or making, people who committed horrific crimes uncomfortable. So, however, for such statements to be protected petitioning activity, they must be, quote, reasonably likely to elicit public participation in an effort to affect, i.e., bring about governmental consideration of an issue, emphasis added. So the statements that are the subject of the defamation claim clearly are not." And he cites Global Naps again. So anti-SLAPP law does not protect tangential statements intended at most to influence public opinion in a general way unrelated to government involvement.
And maybe that's where the second time they cited it that I meant to wait and have you pause on. But you can see we did Global. That's the two people having the telecommunication companies. The statement was tangential. It wasn't really touching on anything to even influence public opinion. It was in a general way. But that's not what. There's nothing general about the way he was trying to influence the public here at all. At all.
Yeah, I mean, there's no question that everything that Aidan has done with respect to the people that lived and were visiting that house that night, everything he says and does has been under the guise that they're the ones who committed the crime. All of it has direct relation to that. All of it. Everything that he says and does has been to apply pressure to those people in order to get the government to do something. So that so many people are like, oh my God, why aren't they looking at these people? Like, what is going on? I don't understand it. What the hell? Do something. I mean, whether or not it's been effective is not at issue. That doesn't stop the acts from being petitioning activity. Just because the government's not been responsive doesn't make it not petitioning activity. The people inside that house remind me of the kind of shit that the Ramsey family went through after Jean Benet. So, I mean, people still, I've been with John Ramsey at some of these events. Super sweet guy. I happen to completely believe they had nothing to do with their daughter's death. That guy goes through it every day, still, decades after. He never stops hearing it from the folks that are just convinced that they had a hand in it, and I mean, it's the same shit. But in those situations, those people have no reach. The people just harassing him when he's walking down the street. You know, it's like, that's, I don't know. All right, let's see, where were we? Were we down to other claims? No, clearly not.
No, not yet.
So anti-SLAPP does not, wait, okay, anti-SLAPP law does not protect tangential statements intended at most to influence public opinion in a general way, unrelated to general involvement. And then cites Cadle, website designed to disseminate to the public information about the plaintiff to attract clients to defendant's law practice was not reasonably likely to enlist public participation in an effort to affect such consideration.
So again, there he's the attorney is publishing statements about a debt collection company's practices on his website, but not as a member of the public who has been injured or that wants to bring this to people's attention, you know, or be alleged, you know, somebody affected by the alleged practice, but as an attorney advertising his legal services. So I mean, that was literally he's just using cases that don't have anything to do here, because and that's all I want to say on that, I guess. Because that's this whole thing about, well, it's a statement that concerns a topic that has attracted governmental attention. Like, just because, yeah, debt collecting, you know, bad practices by debt collectors is something that has attracted governmental attention. But literally, he is not bringing awareness to do anything. All he's trying to do is get clients.
Yeah. It's getting clients.
You're not protected for that.
You're not protected. All right. Other claims. Kearney's motion to dismiss motion as to the plaintiff's other claims for IIED and NEID, civil conspiracy, and Chapter 93A similarly fail because the claims are clearly not based solely on petitioning activity. These claims go beyond Kearney's statements calling the plaintiffs murderers, which, as explained above, are themselves primarily not petitioning activity, and seek redress for his actions in purportedly organizing the rolling rally mentioned above, publicly releasing the plaintiff's personal identifying information, harassing the plaintiffs and their family members, and encouraging others to do the same. Conspiring with Reed to cover up her crime by wrongfully
Conspiring?
Yeah, I mean, conspiring with Reed to wrongfully accuse the plaintiffs and operating a commercial enterprise selling merchandise featuring the plaintiffs' names and likenesses. As to these claims, Kearney also has clearly not satisfied his initial burden, and therefore the motion must be denied. Okay, petitioning. So this is B, petitioning in one's own right. So even if Kearney's conduct that is subject of the challenge claims could be considered petitioning activity, his motion fails for an additional reason. The anti-SLAPP statute provides that a special motion may be brought for claims against a party that are, quote, are based on said party's exercise of its rights of petition under the Constitution. And that comes from 59H. The phrase is read, quote, as restricting the statute's coverage to those defendants who petition the government on their own behalf. And then he goes on to cite Corbin. The statute is designed to protect overtures to the government by parties petitioning in their status as citizens.
Which he was fucking doing, period. Right. And he cites the Cardno Chem case, which he's about to get to, but just misapplies it.
So although the party bringing the special motion need not be the beneficiary of the particular cause, the party who seeks to advance protections of the statute are limited to those who engage in petitioning activity in their own right. Again, citing Cardno. So here the FAC alleges that Kearney was not speaking on his own, but rather on the behalf of Reed. Who gives a shit what the plaintiffs are saying? It's like the whole Gretchen Voss article, like hit piece, like butthurt reporter ridiculousness that I cannot believe that the editor-in-chief allowed to get out to press. Like that thing's getting published in, like, I mean, it's the entire House defendants, like that article, in its entirety is their entire narrative. It's like it was fed to Gretchen Voss directly from Kate Peter, because it's exactly what they all say, you know. So at any rate, the FAC alleges that Reed found and enlisted Kearney to publicize a story about the plaintiffs, and that Kearney agreed to and did publicize and widely disseminate Reed's false claims about the plaintiffs and others in an effort to destroy the reputations of these individuals so that Reed could evade responsibility for causing the death of O'Keefe. FAC paragraphs 22 and 25. It further alleges that Kearney acted on behalf of Reed in publishing defamatory statements about the plaintiffs to assist Reed in her trial, and that Kearney used information in his blog posts, which Reed funneled to him with knowledge that he would publish it on her behalf.
I'm going to wait till we get through this section.
Okay, in stark contrast to the allegations in the FAC, Kearney characterizes his statements as an effort to raise awareness about police corruption, which he contends is his long-standing cause. He argues that, much like the defendants in Cardno, he was petitioning on his own behalf as an activist and as a citizen. In that case, the SJC concluded that environmentalists sued for defamation based on statements made in the Huffington Post criticizing a scientific consulting firm, and purportedly defended polluters were engaging in petitioning activity because they expressed their own opinions, were speaking for themselves at their own behest. Kearney's comparison to the defendants in Cardno misses the mark. The statements that are the subject of the plaintiff's claims in this case have nothing to do with police corruption. Really? The FAC does not seek to hold Kearney liable for accusing public officials of a corrupt failure to investigate the plaintiffs for the killing of Officer John O'Keefe, as Kearney contends. Rather, it cites Kearney's repeated accusations that the plaintiffs are cop killers and murderers who lied about what happened with O'Keefe. Given the content of the statements, it is more than a stretch to conclude that they were in furtherance of advancing Kearney's stated cause. Moreover, while Kearney's affidavit states that he wrote his blog post on his own and Reed did not funnel him information, it does not refute the allegations that Reed enlisted Kearney to publicize her story and that he did so to assist her in trial. Thus, unlike the defendants in Cardno, Kearney has not shown that he was speaking for himself at his own behest.
Okay, so let's just fucking stop there. Okay.
Oh yeah. Can I go get a drink? Are you about to go on a rant so I can go get a drink?
I mean, you could go
rant. Go rant.
All right. So there's like a ton of things right here. All right. So under the ruling in Bristol Asphalt, a judge conducting a first stage review is restricted to facial structural review of the pleadings and the affidavits, things of that nature. So not just the pleading itself, like the complaint, to see if the claims are based on petitioning. But Judge Gildea denies Aidan's motion at the first stage because the first amended complaint alleged he was not speaking for himself, but he's enlisted by Reed. But by treating the plaintiff's raw, unproven allegations of conspiracy as an established fact to defeat a motion at stage one, he's ignored the rule that a citizen does not lose their own right to petition simply because they advocate for someone else under the exact case that he is citing to. That citizens have an independent right to speak out on matters of public concern, like police corruption, regardless of personal self-interest or the self-interest of somebody else. So when he's trying to say, first of all, it doesn't even need to be said again that you can't say they were corrupt without saying these guys are murderers. They're one in the fucking same, period. Okay? Period. So man, I forgot where I was going with this.
Was it because I came and sat down and you saw my handsomeness and you just lost track?
Yes, of course.
Oh yeah. Oh yeah.
So, like, when the court says that even if it's all petitioning, he loses anyway because he wasn't petitioning in his own right, and he's citing the cases that he's citing, it's implicit contradiction. The Corbin case was a psychiatrist, right, who was retained and paid by the Board of Registration to serve as an expert. That's it. You can't be a hired person. You can't be hired to put forth the exact, theory that you're trying to claim. You have petitioning. It's petitioning activity for you to say it. And then in this other case, the Festolo case, that was a reporter assigned to write about those specific types of news accounts. So both turned on their role as an agent, you know, who or a professional with no viewpoint of their own. So in Cardno, the one that the environmentalists, they reframe the test there. Did the speaker, quote, express their own opinions? Were they speaking for themselves at their own behest? The judge is trying to like put it in some box like, oh, but it wasn't at his own behest because she asked him to do it. So they are claiming. If let's say that some local person in the Cardno case went to this group and said, hey, look at this chemical company and what they're doing. Can you help me get this out there? And then they look at it and they're like, oh, this is awful. Look what they're doing to our environment. How in the hell can the judge say that you're not doing it at your own behest or putting forth your own views? Being enlisted and in speaking in your own right are not mutually exclusive. No Massachusetts case says a citizen forfeits the right to petition because somebody asked him to speak or because his advocacy also helps someone else. I mean, sources feed journalists and advocates every day. And like the whole nothing to do with police corruption, it's contradicted by the record. And again, this is not a 12B6 motion. He's got to look beyond just the complaint, you know, and starting with the headline of the very first challenge post, corrupt state trooper helps Boston cop murder fellow officer. I mean, are you kidding me? So it's like the judge is saying here, if we read that sentence again, his affidavit doesn't refute the allegations. Whose burden is that? Kearney swore out an affidavit saying that he wrote his own material, period. The judge's answer is, oh, that's not enough because the complaint says otherwise. I mean, if an unproven allegation in a complaint beats a sworn affidavit for anti-SLAPP, then every plaintiff in Massachusetts defeats every anti-SLAPP motion with one sentence. The defendant was somebody else's mouthpiece, and the whole statute gone on a pleading.
Gonzo.
It's like, I mean, there is a counter, you know, that stage one is a facial review of the special opponent's pleadings, right? But that's to identify what factual allegations serve as the basis. Then you have to look to the anti-SLAPP record to see whether those allegations fit in the definition. So there's a piece under asphalt that says, all right, you look to the identity of the pleading, so the complaint, to determine, you know, what the factual allegations are for a particular claim. But when you're considering the phase one anti-SLAPP question, that you have to look at the record, the entire record, their responses, their affidavits, not just the complaint, to see whether the allegations in the complaint fit in the statutory definition. So, you know, the pleading legitimately controls what the claim is about, but the affidavits, the defenses, they can that reshapes it, you know. And whether Kearney petitioned in his own right is not a question about identifying what the claim is based on. It's a question about the movement's status. And Section 59H expressly says that a court shall consider supporting and opposing affidavits stating the facts upon which the liability or defense is based. That's the Corbin and the Cardno case, both decided on the records, not on the complaint, not on just the pleadings. So it's really, it's status is an affidavit question. Frame it like, if you think of it like the judge ignores the affidavit completely, and then he just acts like the pleadings win everything, that the pleadings win absolutely everything. So, you know, there is nothing that says that a citizen who's speaking about a matter of public concern is now not petitioning activity just because somebody enlisted you to do it. Somebody brings it to your attention. Somebody puts it in front of you. He's citing cases where someone is paid to do that job. Hey, you've got to go write about this case, you know? And the allegations don't rule the day for that. He's got to look at the underlying facts for it and what's in the record, the overall record.
Yeah. I mean, it's like he's going beyond, taking what the plaintiff said in the light most favorable to them. It's like he's adopted it as truth. Like, that's the way it reads. You know what I mean? Like when he's writing these things, like he's accepting it not in a light most favorable, but he's accepting them as if it's gospel, like what they're saying. Well, like we didn't murder them, so it's like just they're lying. Well, that's yet to be determined. Like at this point, you know what I'm saying? All right, let me keep rolling here. So,
and then just last thing with the Cardno Chem case, they
babe, I got to get lobster rolls.
Okay.
No, go. I kid.
I mean, it's just like at like on appeal, because again, the judge is ruling that the complaint alleged Reed enlisted Kearney to run a PR scheme, and Kearney was, Aidan wasn't petitioning on his own right. That when they do the appeal, the counsel can argue that he's, that checking an individual's subjective background, sources, all that stuff at stage one completely overrides what Cardno says. Like, an investigative blogger has an independent First Amendment right to expose what he genuinely believes is a corrupt police frame job, regardless of whether the criminal defendant is feeding him the inside scoop. Period.
Yeah. I mean, seems pretty clear cut. I mean, look, here's the bottom line. If they elect to appeal, they're going to have some strong case law to argue. You know what I'm saying?
They're
like in terms of
going to appeal. That's what stops the whole freezes discovery.
You just spoil alerted it. Or wait, you just spoiled it. All right. All right. So, and by the way, I saw you guys, I heard you guys, I felt y'all. I turned off the ads about 15 minutes ago. So if you haven't been getting ads, you're welcome. All right. So back to the body. While the anti-SLAPP statute provides, quote, very broad protection for petitioning activities, it was intended to protect the rights to petition the government for the redress of grievances guaranteed by the United States Constitution, Durcraft. So where there is no reasonable basis to conclude that Kearney's statements and conduct at issue in the plaintiff's claims were in an effort to petition the government for redress of harm, Kearney has not carried his threshold burden. So he moves on to Karen's. Defendant Reed's initial burden. Okay, so the plaintiff, how much case law have you pulled on this one, babe?
Much less.
Oh, thank God.
But I've got some.
Okay. All right, so the defendant, the defendant Reed's initial burden. The plaintiffs assert claims against Reed for defamation, IID, and IED, and for aiding and abetting in Kearney's defamation and infliction of emotional distress and civil conspiracy. Reed has failed to show that the claims are based solely on her exercise of the right to petition and have no other substantial basis. He goes down to footnote 6.
So let's not read the whole footnote because we all know what it says, that Reed didn't address the issues. He has no idea why. But what the last sentence here is you've got, so he says, Reed clearly should have anticipated that the opposition would have addressed the negligent factual allegations. Nevertheless, the court has considered her arguments in the brief and finds it unpersuasive. That's the saving grace on appeal, because they did consider it. If they would have said, so we're not considering it, I didn't research that issue, but the court would likely say, well, yeah, you violated the rules. They don't have to consider it. But the judge saved Karen Reed's team right here.
Yeah.
Because he says, nonetheless, in his discretion, he's decided to consider her arguments in the reply brief. So
meaning
they still didn't do great in the reply brief, but at least they touched on it.
Yeah. I mean, at least it wasn't waived. At least it wasn't addressed at all. Yeah, that one little sentence is a big deal. It's a very, very big deal. Because otherwise the issue wouldn't be able to be raised. It wouldn't be a question in front of the court because they never So that, yeah, that
I mean, it
judge
is
could have-
possible that there would have been arguments that, you know, the courts usually like to.
Yeah, but who wants to, like,
Right.
that's where you're spending all your time trying to make up for your fuck up. Like you're spending so much time trying to make right what you should have made right the first time. You know what I mean? Like we've had it. We've done it, you know. It's like those things where you're trying to like oops, made a blunder, and you spend a huge amount of time finding research for a way to wiggle yourself back in and get everything the way that it should be. All right, so let's start with the defamation claim. So Reed's motion cites a handful of allegedly false statements she made about the plaintiff, which she contends form the basis of the defamation claim and fall under all 5 categories of petitioning activity under 59H. Her motion, however, neglects to address many allegedly defamatory statements, which form a substantial basis of the plaintiff's defamation claim and which cannot be characterized as petitioning activity. For instance, the FAC alleges during Reed's first trial, she had a documentary filmmaker, Terry Muir, record the trial preparation, which included conducting recorded interviews with Reed over the course of the trial. During an April 30th, 2024 interview, Reed stated that, quote, Jen McCabe is a first-degree murderer and she knows it. And that the plaintiffs know that they killed John, and the plaintiffs are murderers and they know it. The FAC also alleges that during an interview on June 15th of 2024, Reed told Muir and her team that Brian Higgins, Brian Albert, and Colin Albert had a motive to kill John O'Keefe. And that during another interview on June 22nd of 2024, Reed told the filmmakers, I know Brian Higgins had a role in helping kill him, help him get in the snow and help frame me. But I don't think Higgins necessarily would have wanted to really hurt John. I think Brian Albert and Colin Albert would have enjoyed roughing John up. So although Reed did not address her statements to Muir, am I saying that right? Muir, I think so. In her special motion, her reply brief argues that they fall under second, third, and fourth clauses, which we've gone over multiple times, of 59H. However, she failed to establish this is the case. So as explained above, for statements to be reasonably likely to encourage consideration or review of an issue by a legislative, executive, or judicial body, they must be directed at an authority that could affect such consideration. The production staff of a documentary film is not such an authority. There is no plausible argument that the statements Reed made to Muir and her team were, quote, reasonably likely to enlist public participation in an effort to affect such consideration. So,
just on that, and we're going to get into it more as he says more, but like, how is she supposed to know what part's going to be aired and what part's not? You know, and we're going to get into the timing. Like, as soon as he gives us the shit, I think it's like the bottom of, what page are you on? The bottom of page 14.
12 I'm on.
Yeah, we'll pause again, but you know, like, statements to a film crew aren't to an authority that can act because they're part of a documentary film about the trial that Reed could not have reasonably thought the statements would be released to the wider public until after the verdict. He said that part already. You got to that, right?
No, that's coming up next.
Oh, okay.
There is also no plausible argument that the statements Reed made to Muir and her team were reasonably likely to enlist public participation in an effort to affect such consideration. The statements were all made in the midst of Reed's first criminal trial. And in the case of the June 22nd, 2024 statements, 3 days before the jury began deliberating, because they were part of a documentary film about the trial. Reed could not have reasonably believed that such statements would be released to the wider public after or until after the verdict. Okay.
So I mean, we all know why that's like ridiculous, because again, he's just ignoring that she's also, what did I call it before? The multi-objective matrix, like the multi-petitioning activity objective matrix. She can have different reasons at different times. First of all, the thing is still pending, you know, when she says it. And she also still, she's talking about her defense and getting this out to the public. And she also still wants them to investigate the right person. Like we all know that that's what's going on here. But like the release after the verdict, of the first trial means that it's like he's getting into her state of mind with no affidavit to support it. Like that's what Bristol says you don't do at the first stage. She's said that, I think she said, or did she not say actually? I mean, I don't think they put forth the right matrix. And I can't remember if they did. I think.
Are you talking about in their response of pleading?
As far as their objective was to also have them investigate to open an investigation into
of course
people, not just
she's hoping that she's going to get acquitted, and
right,
she's hoping that once she's acquitted that they're going to investigate them.
But they kept arguing it's still in response to a pending judicial proceeding. It's still in response to a pending judicial proceeding. And that's where I just think, yes, it was, but I just think they needed the multi-objective matrix.
To flesh it out.
Right. Also
to deal with what he just wrote right here. They should have gotten ahead of this. And if he would have made that argument, we're talking about Seligson, if he would have made that argument that you're talking about right there, maybe we're not seeing this, but it wasn't addressed. He
completely ignores the civil case. Completely ignores it. Like it doesn't exist. That's still pending when she made these statements, right? Or was that in August of 2024? When was the
No, yeah, that was before. Well, one suit was filed. Like I think the O'Keefe's wrongful death, because they had a statute of limitations issue. So I think O'Keefe was filed
August 2024. So it is after this. So, but he what time?
All right, let me keep reading.
Okay.
All right. Let's see, where was I? Okay, so Reed could not, all right. So Reed had also not established that the statements were made in connection with an issue under consideration or review by a legislative, executive, or judicial body. She argues only that the statements fall under this clause because the judicial proceedings were ongoing, and she, quote, intended to publicize that she had been framed in order to pressure the Commonwealth to drop her prosecution and instead prosecute the true perpetrators. So, however, the fact that she was involved in governmental proceedings does not make every tangential statement petitioning activity. Well, it's tangential to you, Judge. It's not tangential to her.
Right. And it's not tangential either.
And it's not well, that's the point. It's like it's a direct line. It's like there's no tangent there. She's saying I didn't do it, they did. Why aren't you going after them? That's not a tangent, dude. Like this guy is.
And he's citing again to that global NAPS, which is where it was really a dispute between two, competing telemarketing companies.
Yeah. And the proffered motive behind her speech is irrelevant as the threshold inquiry, citing Bristol.
So,
again.
Now he admits that when it's against her, the proffered motive behind her speech is irrelevant. But with Kearney, the motive really matters of why he's saying it. I mean, he's using it against her, and it's supposed to actually be a thing in Bristol that helps her, that the judges are supposed to be relying on the plaintiff's proffered motive behind the speech at the threshold inquiry at stage 1. And then again, he's citing like the office 1. Oh, that was a different case. Never mind. I'm not even going to get into that one.
Get him, babe. All right. So she failed to at any point. She has failed to at any point objective indicia.
No, she's failed to point.
Oh, to point to
which
any
is what
objective.
We've been yelling is the issue.
She has failed to point to any objective indicia demonstrating that her statements to Muir were made to influence, inform, or at the very least reach governmental bodies, either directly or indirectly.
All right, so we've got to just pause here, and I'll
wait. I thought you said we were going to the bottom of 14. I'm at 13 here.
I mean,
all right. I can't deny you. You did so much work.
I know.
Say your piece. Say your piece.
They're moving away from
the people are going to be like, Bob, shut up and let her speak. Speaketh. I guarantee it. Like, I haven't looked at the chat, but that's what they're saying.
So again, he's citing the Bristol and the Office 1 Lopez for motive doesn't matter at stage 1, but he uses motive. He uses motive is irrelevant to discard Reed's stated purpose, but relies on the amended complaints allegation of the defendant's motive to defeat them. So Aidan's statements were aimed at convincing his audience to regard and treat the plaintiffs as a murderer. That he's giving it a fucking motive. And for Reed, and I guess he says it later about like how she chose him, and that what the statements were meant to influence. But again, motive is irrelevant here, and motive is dispositive, before. Like, pick one. And that Office 1 rule is for, again, it exists so plaintiffs can't defeat these motions by pleading that the defendant had a bad intent. And the judge is now turning it around and using it against Karen. And
totally. I mean, like you said, he's got to pick his poison. He can't say that he's civilly conspiring to get Karen's message out and then decide that Karen doesn't have a message.
Or the intent for why she's really doing it, which is in the phase 1.
Right. But deciding that Aidan did have an intent to it's like, he can't have it both ways. He just can't.
And he's basically, by putting this like temporal hair splitting, he's stripping away her like anti-SLAPP shield because of a third-party production schedule. Like, this is a glaring, it should be reversible error under modern First Amendment and Massachusetts anti-SLAPP jurisprudence. The judge explicitly ruled that because the documentary would air after the verdict, Reed could not have had a contemporaneous intent to influence. Because, well, I guess he hasn't said it yet, but he's also saying that her real intent, as he says later, was to influence the jury pool. And so if it's after the verdict, she could not have had this contemporaneous content, but the judge is completely ignoring the reality of the entire, prosecution and the fact that there are still people who have not been investigated. Again, I don't know that they made that argument as strongly as they could have, but under the ruling in the cases he's citing, the threshold question is whether the speech, quote, has a plausible nexus to a governmental proceeding. Hers was still fucking pending. And multi-objective matrix, people remember it. She also wanted them to investigate the corruption, the cover-up, and arrest the people who really did it. So when a criminal defendant sits down, like with a documentarian, to detail her defense theory, her structural objective is to gather public awareness, build a defensive record, force institutional accountability, like forcing a criminal defendant to time her media defense based on the independent filmmaker's editing schedule or lose her constitutional protection is an absurdly narrow restriction that I don't think that the SJC has ever supported.
Preach, girl.
Yeah.
B. Aiding, I just want to say, we've got the most highbrow chat. Like I'm scrolling through, I'll go into various chats, and just in terms of the intelligence level, in terms of kind of like the back and forth that I see in chat is very impressive. You guys are amazing out there. We love you so much. Love you so much. All right, so aiding and abetting claims. The plaintiffs assert claims against Reed for aiding and abetting Kearney's defamation and infliction of emotional distress. Reed contends that her conduct was petitioning activity because it was made in connection with an issue under consideration and review by the three bodies there, and reasonably likely to enlist public participation in an effort to affect such consideration. She again fails to establish the claims had no substantial basis other than petitioning activity. Reed's motion focuses on allegations in the FAC that she communicated to Kearney non-public information that was in the court filings or that was evidence in her criminal trial. She does not explain how her providing Kearney, as opposed to the court, with the police report, with the plaintiff's private addresses, phone numbers, and social security numbers on it, was petitioning activity. And then 59H, petitioning activity includes any written statements made before or submitted to a judicial body.
And it's not limited like that.
Yeah. All right. So even if such communication could be considered petitioning activity, and aiding and abetting claims extend beyond these select allegations. For instance, the FAC alleges that Reed found and enlisted Kearney, quote, an inspiring internet personality with limited reach in the greater Boston area, end quote, with, quote, no journalistic training, editorial standards, or oversight. Well, we saw how that oversight worked for Gresham Voss, right?
Right.
What? Who was seeking attention and money and, quote, routinely engaged in provocation and courted controversy to publish her false statements. And that's FAC at 18. So she then told him that the plaintiffs were responsible for O'Keefe's death, and he broadcast such statements on his blog. Actually, she didn't tell him shit. He read the motion, wherein the defense attorneys pointed the finger at the people in the house. So Reed, like, this guy is acting like that shit doesn't exist in the world and that Karen just cooked this up in her bedroom when she was laying in bed at night. It's not what happened. Like he's ignoring the reality of the litigation that took place in the criminal case, and it's fucking making me insane. Like, is this guy for real? Like I'd be putting the motion as Exhibit A on the next thing that I file when I'm trying to get rid of him. I'm like, all right, you pretend like this doesn't exist in the world and this was something cooked up between Karen and Aidan. I just want to remind you that this is the reality. There's your world and then there's the reality.
Right. And he's doing, so we mentioned earlier, like, if it's all in one count, then the judge he doesn't have to say, you know, as long as there's one statement that they can't reach the threshold and establishes, you know, petitioning activity, then the whole claim survives an anti-SLAPP motion. But he's ignoring the framework that was like restored by the Bristol Asphalt 2024 case. So you've got like 2 Bristol Asphalt cases, which made it clear that while the judge can't like parse a single count, the court must evaluate the lawsuit on a claim by claim and timeline by timeline basis. So he's like denying the whole aiding and abetting thing. He's like, well, we've already said that that's not, you know, petitioning activity. Like, no, you've got to look at this on its own and what is alleged in that one, because again, there was the August 24th. I don't know what date some of this stuff is. If it's, when did the first trial end?
I think it was late June, right?
Of what?
The year prior, I think 23. I think it took like a year to get back. It was almost like they happened around the same time of year. I don't remember the dates.
All right. So then the wrongful death action doesn't get filed till August. So it doesn't cover the Muir statements.
I guarantee you there's people in chat that know all the dates.
I just looked at it. It was June of 24 and the wrongful death was filed August of 24. But there is a post August 24 speech that they bring up, and he completely ignores the pending civil lawsuit.
Okay. Can I continue? May I continue?
Yes.
May I go back to the body? All right. So she then told him that the plaintiffs were responsible for O'Keefe's death, and he broadcast such statements on his blog. Reed's motion does not address how such statements have a plausible nexus to a prosecution. Huh? What the fuck is he talking about? Indeed, the fact that Reed chose Kearney as an outlet for her statements, knowing he would convey the information in a way that would provoke and inflame his audience.
Wait, what? How's he know again? So he's what the fuck is he relying on? She did it because she knew he would do it in a way that would inflame his audience, as opposed to fucking starting an entire movement, which
she didn't know this dude from a hole in the ground.
And he started an entire movement.
And she didn't know how he was going to go about doing it. She knew nothing about him. She didn't know what his style was. She didn't know if he was a dude who went out and got in people's face. Like, she didn't know any of that shit. Like, somebody told her, like, oh, this guy, no, put it back up. Put it back up. I got to read, dude. I haven't eaten all day. It's
all right. But then the other thing is just like, this goes to show, like you were saying before, how it's right. It's he's putting his internal thoughts in writing, you know, like he thinks that Aidan is somebody who would, provoke and inflame his audience against the plaintiffs, as opposed to someone who would start a fucking free Karen Read movement, a hold the government accountable movement, which is what he actually did, Your Honor. He didn't just inflame his audience against these poor innocent people. Oh, he got them to not like them and to think of them as murderers. Well, thinking of them as murderers is start one for knowing the government isn't doing what it's supposed to in this case. Somebody's framing an innocent person. They're not looking into public corruption. They're not investigating the real perpetrators.
And beyond that, like, this implication that there's something untoward about defense attorneys talking to the media or a defendant, which we would never advise our defendant to do, but they're able to do it, especially if they're out of custody. If they want to talk to the media, there's nothing prohibiting that from happening. Now, whether or not it's a good idea, a completely different situation. So if you find a reporter who's got the ability to listen and maybe even is thinking, well, you know what you're telling me isn't crazy, I'm going to dig into this. Good on you. Good on you. I mean, when we were trying Garcia, we only had one reporter that was willing to listen at all, because everybody in that town, in terms of reporters, had, Garcia pegged before trial. And there was one guy. And of course, we invited him out to our office. Come on, we'll show you the war room. Like, what, you know what I mean? It's like, there's nothing wrong with that. And if you've got a reporter who then, and the one thing that I'll never forget when we saw it was when some of the text between Karen and Aidan came out, and you saw the reality of the situation where Aidan was giving pushback. Like, he wasn't some lackey lapdog. And I think it had to do with the Google search or something like that, where he's like, I don't know, like, what I've gotten myself into. Like, he was giving pushback. This wasn't some guy who just like bought what he was being sold and ran with it. Like, he believed it. Like, there's actual messages that reflect that reality with him, like, do you remember what I'm talking about? I can tell you don't. Oh, you weren't paying attention. You were reading. I see. All right. So Reed's motion, back to the body. Reed's motion does not address how such statements have a plausible nexus to a prosecution. Indeed, the fact that Reed chose Kearney as an outlet for her statements, knowing he would convey the information in a way that would provoke and inflame his audience against the plaintiff, suggests that the statements were not meant to influence, inform, or bring about governmental consideration of the case. It's like when I'm reading the words that he writes, I'm like dumbfounded, like, truly. So statements to the Boston Globe, a newspaper widely circulated in Boston and throughout the Commonwealth, were likely to reach the decision makers at the Department of Mental Health and members of the public wishing to weigh in on a licensing decision. And that's from Blanchard. Right, dude, like, this guy does not understand social media and the power and the reach of it. He just doesn't. He has no idea. He's sitting there, an old white guy on the bench who's out of touch with reality that is our current reality. Like, he's living 2 decades ago in his mind. Oh, the Boston Globe. Nobody buys newspapers anymore. Like, I don't even know. I guess you can still find them in print. It's damn hard. Like, I haven't seen a newspaper box. Like, when the Bears won the Super Bowl way back when, or the White Sox won the World Series, I would go to a paper box, and I'm admitting that I may have taken more than one copy of like the hard copy newspaper for, keepsakes. I haven't seen like a paper box in front. Point being, the world has changed. Where we consume and get our information is online, and a mass amount of the information that I consume is on social media. That's where I get it. I find out about things almost exclusively from social media, whether things have been filed. I've got great people like, you know, whether it's Corey or Kyle or Dee, whoever, with respect to the Karen Reed world, I know when something's filed immediately because I'll see them post an X. I'm like, oh shit, the judge's order came down. Oh shit, new motion to dismiss was filed. Like, that's where I get my news, you know, and this guy is just like out of touch with the reality of the world that we live in. And it's bleeding into the way that he's viewing this case, and it's problematic. And it's problematic in every case, not just for Gildea. All the judges that are out of touch with the reality. It would be like my dad. My dad's brilliant guy, but he has no idea about social media and the reach and what, like, he barely understands that we have a YouTube channel. You know, if he wants to watch us, he tells us, like, turn it on for me. I don't know how to find it. I don't know what it is. You know, what is it? Is it a real TV show? He still doesn't understand the concept of it.
Which goes directly to the next paragraph that we're going to pause after.
Okay, so thank you for the warning. Nor does Reed explain how the content of her statements to Kearney, accusations that the plaintiffs murdered O'Keefe, either directly or indirectly called on members of the public to appeal to the government on her behalf. Statements with, quote, no potential or intent to redress a grievance or directly or indirectly to influence, inform, or bring about governmental consideration of the issue lack a crucial characteristic of petitioning activity.
First note, he's citing that global case, which again, it was tangential statement, you know, about basically putting down a competitor with some like, oh, well, I was going to appeal to the to some board, whatever. But I'm sorry, is her telling a reporter the information? How in the hell does the judge say that you moved off of it, so now
I'm sorry, babe. Sorry, I'll move back up.
Oh, I was looking for it on my computer anyway.
I got it.
So she doesn't explain how statements to Kearney, accusations that they murdered them, are directly or indirectly called on members to the public. So to appeal to the government on her behalf. How in the hell is giving the information to a reporter to report publicly on, not indirectly or directly calling on members of the public to you know, influence the government on her behalf? It's absurd, because guess what? If she had just said it to Aidan and Aidan didn't do anything with it, like start a fucking movement, then what would their damages be? They'd have no damages, which is not a stage 1 question, but still they'd have no damages because it would just have gone to this one guy. I mean, maybe you can, I mean, I guess technically you accuse somebody of a crime that they didn't commit. There could be nominal, you know, like damages, but there'd be no harm to them because nothing came of it. So how he writes the words that she doesn't explain how giving information to Kearney could do anything. I think the whole fucking movement explains how giving to Kearney information, you know, it puts that in front of the public. But maybe because they weren't responding to the amended complaint, so they didn't flesh this out all that much. And her reply was, I think, like 4 pages. I think it touches on it some, but still, I mean, he's just being thick. He's being thick, and then he's comparing it to a case where clearly they were not trying to, you know, get even indirectly inform the public or do anything to bring about the government consideration of the issue. They were just bullshit talking a competitor.
Agreed.
So,
all right. Other claims. The remaining claims against Reed alleging intentional and negligent infliction of emotional distress and civil conspiracy all have substantial basis other than petitioning activity. The claims allege that Reed orchestrated a campaign of harassment against the plaintiffs, which included funneling information to Kearney and hiring a private investigator to confront the plaintiffs, that she and Kearney agreed to scheme to defame, harass, abuse, and intimidate the plaintiffs, that she provided Kearney with non-public and confidential information about the plaintiffs, and that she celebrated the destruction of the plaintiffs' reputations while monetizing the publicity. Reed's motion.
None of that should really matter, because they're maybe not what's the word? They're not the incidental consequence of it, but they're just like a consequence of it. There was some cases I was reading on this, but in any event, the judge like literally like the logic creates like a massive recursive loop that completely ignores the relationship between anti-SLAPP and the other claims, because this is derivative liability. You know, it's long standing under Massachusetts precedent that you cannot be held liable for aiding and abetting a tort unless the underlying conduct itself is legally actionable. So if they are, some of this is petitioning activity, or then you can't depend on get aiding and abetting to like circumvent the fact that your actions are constitutionally allowable. They're constitutionally protected. And what the courts look at is the act, you know? So at like stage one, the aiding and abetting claim should collapse like automatically, because it's all the statements that they're mentioning there are petitioning activity.
Yeah, they're just trying to do an end around. Like they're just trying to do an end around. Like you were explaining this to me when I was like, you and I had a conversation about this exact thing. And you're like, no, that's like really all they're doing is an end around to try to, you know, drive this claim through, even though it really relates only to the petitioning activity itself. Because that's the underlying act, really, is the petitioning activity. You know, and they're just trying to find a way to work around it.
And they still have those arguments in their Rule 12b-6 motion, because again, that's where the judge can go statement by statement, action by action, and say whether they can rely on this, whether they can rely on that. And then they would just be stuck with some bullshit, I think. But I mean, we won't know until there's a ruling, and maybe something that the appellate court says will have some influence on the 12b-6. But you know, we have to get to that at the end here.
All right. So Reed's motion does not attempt to explain how any of this conduct could be considered petitioning activity. Rather, she argues that all the claims are based on Reed's alleged defamatory statements to Kearney, which she contends were all petitioning activity for the reasons stated above. The court concludes they also are not. Because Reed failed to show her statement and conduct at issue in the plaintiff's claims were an effort to petition the government for redress of harm, she has not carried her threshold burden for the anti-SLAPP motion. The court therefore need not proceed to the second step of the analysis, and the challenged claims will survive. Order. For the foregoing reasons, Defendant Aidan Kearney's special motion to dismiss plaintiff's first amended complaint pursuant to anti-SLAPP is denied. Defendant Karen Reed's special motion to dismiss pursuant to anti-SLAPP statute is also denied. There you go.
All right. So here's what we think is going to happen. All right. I would say they have 30 days to file their appeal, their notice of appeal, which triggers an automatic stay of discovery. I think that they'll probably do on Monday, unless they have some other claim. Then they've got like 1 to 3 months to assemble the record. So the Plymouth Superior Court clerk has to physically gather, you know, all the complaint, the motions, the exhibits, and put them in an official record. Then you've got docketing, which is like 10 days after that. So once the record is assembled, the defense has 10 days to like pay the fee and get the case docketed. That's sort of nothing. And then and then you've got like the bypass. So it's not going to, I don't think it stays in the appeals court, but because the case is like the question framework, they'll probably immediately file for, you know, direct appellate review, asking the Supreme Judicial Court to take up the case. And then you've got like 6 to 9 months of probably briefing schedule and argument. So you have 40 days for the defense brief, 30 days for their opposition, and then 14 days. So all in all, it's like the next 9 to 12 months is this. And it completely locks down the plaintiffs, you know, like
it stays the case. Nothing happens.
Right. So, but then it begs the question, well, what about these 12b-6 motions? Because those aren't appealable on the same track as the anti-SLAPP, and they haven't even been addressed yet, and there's no time for lawyers to be addressed. I mean, I think that Aidan's lawyers asked for a hearing, which surprised me. And it might be that they've got enough lawyers to kind of separate it out because someone's got to be working on all of this. But I would have expected them to maybe wait, but they probably have a better idea of how all this stuff works and how it should get. But so these got the unresolved 12B6 motions. You've got the one that Aidan filed against Higgins and Albert, saying that they're public officials, and to dismiss that. And then Karen's got multiple 12B6 arguments on all the claims. So a standard 12B6 denial is not immediately appealable under the same doctrine of present execution or whatever it is. So I don't think, but maybe they are. I wouldn't have thought that they'd push the judge to a quick hearing, but either way, they can file a motion to stay that, and then they can move to see if the court will do what's called like pendant appellate jurisdiction over the 12B6 issues. And I don't know how often it works or how often it doesn't, but they can say like, well, the trial court, failed to analyze our 12B6 defenses, and they're inextricably intertwined with like the First Amendment speech stuff. So take jurisdiction over the entire pleading block and like rule on them simultaneously. And if they were to grant that, then that the court would look, do the allegation by allegation, statement by statement within the defamation case.
Well, let me ask you, in terms of the timing of it, I mean, they clearly want him to rule on the 12B6 stuff before they file the notice of appeal, right? I mean, because like you don't want that pending, do you?
Well, that's where let me look at what he filed, because they filed something. So let's take 2 seconds here. Let's see.
All right.
Name.
And while we're taking a break, I promised Tracy, and more importantly, myself, hey, if you love our community and you want to take care of our mods who are amazing, and you can see from the chat, like there's going to be opposing opinions. We don't want an echo chamber here. We want people to be able to argue, but you have to be civil. Just be nice to one another. It's possible to do. I do it every day. I do it all the time on Twitter. Like you don't have to attack people. And if you're attacking people, that means you don't have a solid argument on the other side of it. Just know that. But if you love our mods, there's a way that you could show them a little bit of love financially. They've created it's a buy me a coffee, but they have buy me a slice of pizza. We'll drop that in chat. Give till it hurts. Help our mods out. They deserve it. They work so hard. They're here all the time. They're making our channel what it is. They make our community what it is. They make this a safe space for people to come and hang and disagree or agree. But whatever the case may be, we love our community so very much, and our mods are just integral.
We make them work hard. We put them to work.
We do.
Especially Tracy.
And they never know when we're going live.
All right. We never let them stop.
We show them no courtesy. Like, oh yeah. Or like, here's no heads up. We're live. Hi. And they're like, what the fuck? This guy. Like, this guy doesn't even tell us we're going live. So they put up with our shit. They're amazing. They're all wonderful people. So show them some love, please. Because Tracy takes it all in and she divvies it out to all of our mods that work so very hard for us. So make sure you're doing that. Please, please,
yes,
please.
So, I can't say, because all Aidan did is file a request for a hearing. So defendant respectfully requests a hearing. Now that could be just like you got to put that request in and then it's preserved, and they might still file their appeal and seek to stay everything. That's what I think they will do. But that's based off my little bit of review of the procedures in Massachusetts. He's got lawyers who know what the appellate or the SJC courts will do, what they won't do, if this is even something, that would work that way. But my initial kind of thought is that they would stay it and ask the appellate court or the SJC to consider it all under their, under the whole pendant appellate jurisdiction. And maybe they ask that, and if the court's like, no, I'm not taking up the 12B6, then maybe they say, let's go to hearing. But I don't know. That's kind of what I think that they would do, because they don't have time, I don't think, to go to hearing, have him rule all before they've got to get this stuff, you know.
I mean, he might fire out his 12B6 early next week for all.
But then, no, they demanded a hearing.
Oh, they did?
Yeah, that's what I was just saying. And then that might just be, at first I was thinking, well, maybe they aren't going to wait because they demanded a hearing, but that just might be like, so he knows, don't rule, I've demanded a hearing. And then maybe they still are going to stay those proceedings, file the appeal, and ask that they consider it under the, you know, as part of the anti-SLAPP under their pending appellate jurisdiction. And I think it would be a successful pitch because those things really do, they are intertwined. And then, you know, you've got Karen's got her group libel doctrine, you know, that he didn't address, which is true. So they have to kick out some of this. They have to kick out some of the statements. Everything that we have said in the past about some of these statements, just not, you know, the judge even says, like, I agree that X, Y, and Z is petitioning activity, but not 1, 2, and 3. So when you get to 12B6, it's going to parse each statement. And then like something like someone in that house killed John O'Keefe, that's gone, you know. It doesn't do anything. And then you've got like the litigation privilege that she alleged. That's going to get rid of some of it. So I still think that some of it's going to get Karen and Aidan are going to get, you know, kicked. And then you've got like the derivative accounts that really rely on it. So I think they could like get this kind of 2-track strategy with appealing the anti-SLAPP, freeze discovery, wait on the 12B6 and ask the court to review it. And then the lower court can't do anything if they decide to do it. You know, plus they could just say, well, we don't want you to rule. I would probably say, even if the court won't review the 12B6 issues because the judge hasn't ruled on it or for whatever reason, like to wait, because I'd be hoping that they'd get a bit of a slap down from the appeal, even if it doesn't go their way. But there's also the risk that it slaps down the other way, I guess. So I don't know. I guess we'll have to see. It's a chessboard, you know?
Yeah, definitely. All right. So at this point, let me shout out the Venmos that came through, because we got a few of them. Our daily Venmo angel, Kim, $25 per usual. Thank you so much, Kim. Thank you both. Thank you so much for that, Kim. We appreciate you always and your incredible generosity. Birdman came through with 25. Hello, it's me, Birdman. Allie, great interview with Aaron Spencer's attorney, Aaron Casanelli. If you guys have not watched that, you should really go check it out. Allie carried the day because I had to leave, and her and Aaron were spectacular. There's a lot of like intense, kick-ass defense attorney mojo going on in that interview. Two badass women going at it, and it was a fabulous interview. So I highly recommend that you check that out. And he says seeing him pop up, and he's talking about Aaron Spencer had popped up during the stream, which I didn't even see. Seeing him pop up on the stream to say hello, warm the cockles of my heart. I hope you and Bob enjoy your perfectly timed vacation. Yeah, right. Timing is everything in this life. Thank you so much, Birdman. We appreciate you. And then Sharon had sent a $25 Venmo. Congratulations on reaching 70K. Yes, thank you guys so much for getting us over that hump. We appreciate you guys so much. Thank you for all that you and Allie do. Thank you so much, Shannon. We really, really appreciate that. And then Stephanie Ann, $10 on the Venmo. Great show. Thanks, Bob and Allie. Thank you, Stephanie. We appreciate that so very much. And then Jen, thank you so much. Jen, you didn't put your damn screen name on here, and I know what it is, but it escapes me. Send us 5. Great work, Allie and Bob, on the live. Judge Gildea is cooked. Congrats on 70K also. And yay. Thank you. All right, so that'll do it with that stuff. I've been trying to go through the supers. We got a lot of the jewels, tons and tons of jewels. So do you want to handle these while I take my dad to this place? Because we're
No,
meeting. We're
the-
meeting.
I want
the
to
Wed-
go. No,
All right.
all right. No, I don't have time. You're right. If we're meeting our friends, but
Yeah, because we
I
have
think
to
that
leave
we
here at
just
4:30.
I put up a lot of the jewels. Like I'm not.
I was putting them up. I didn't see. Were you doing it
Oh,
too?
I did it
I don't.
too. Where is
Oh,
when does I think we got most of them
let's see. No, I think I stopped at.
right there. Yeah. I mean, thank you guys all for your jewels and your gems. It's,
There,
ooh.
and then, but address the questions. Like, so
I will,
I
of course,
know,
address the questions.
yeah, I know that, there was where was it? There was a
Here's
question about whether Gildea actually clicked on the link, on the links that were contained. There's no way. This guy
no,
did
no
not
way.
watch shit.
No.
Like, not a chance, not a chance. Like, he went on the papers. That's it. And he's just leaning into the plaintiff's allegations in terms of what they're saying, and that was what he based all his shit on. So
Yeah. And Lola, the good dog asks, is Officer John O'Keefe case officially considered an unsolved open investigation since Karen Reed was acquitted? No, it would only be that way, as far as my understanding, is if the police label it that way. If they decide that that maybe they, because obviously we know the state's position is the right person got off. So they're not going to consider it open. I'm sure in their file it's closed. So the status would change once a police officer decided, hey, I think there's something here worth investigating, and they got the ability to reopen a closed case. Because you don't even get to an indictment, because the rest of the question is, does the status change once there's an indictment? The status changes once there's the police start an investigation.
yeah. All right, I'm gonna
BB,
dip. I love
all
you.
right,
I love you guys.
love you.
Make sure you
Wait,
like,
don't
share, subscribe. What?
just turn off your camera
What do you mean?
in case you come back.
Wait, I won't. Wait, you're still gonna. What? I don't understand. What are you getting at?
Just
Just say it. Just say the words.
leave your little box there.
Like, so do this.
Yes.
Okay, I'll leave. Oh, Allie doesn't love you.
Love you,
Bye.
bye. All right. So, wait. BB King says, love you guys. Is this appealable before trial? Yes. And we answered that. So I know that some of these are old questions. Also, this judge seems biased. Can they ask for recusal? I mean, I agree that there's so much in his words and the other things that have happened with the rulings about, was there a leak, and this is what Aidan said on social media, like that he's showing an internal bias. Whether it's enough for recusal, I can't say. Thanks, Barry Adams. Congratulations and 70 subs. Appreciate that. We appreciate all the jewels. And I don't know what the jewels and gems are different. I don't know what that's all about. GA Cat Mom says, we appreciate Allie's hard work, and you too, Bob. We appreciate you. 1,000 jewels. More jewels. We appreciate all the jewels and gems. And then Java Jolene says, for Allie's passion, chamomile tea. Thank you for your generosity. Got more jewels and Uncle Alerts. A marshmallow saying hi. That's a new one. I don't know if maybe we did see that one. Thanks, Traveler and Party Blowers. Oh, Michelle Polson. Welcome. Family hug. And then the Traveler says, it's only petitioning if it's for yourself. No, bullshit. So a man couldn't petition for pro-life or choose because that's for someone else. Exactly. Exactly. The judge's logic is one of the issues I feel very confident that an appellate court or the SJC is going to be like, no, you got it wrong. We saw it in I think the global case with the footnote that we read. Blessed Texas Lolly, thank you for your continued support. 14 months. Y'all are the best. Thanks for all you always do. And thank you. Thanks, Travis. Cat Lady Ballerina official says, can I get, he's giving it a fucking motive on a shirt, please. I mean, we could try. But he is. The judge is just giving it a fucking motive and then saying, oh, the motive is not something we consider in stage one. Oh, really? Then why did you give it a fucking motive? Thanks for the jewels and the gems. Maybe they're all jewels now. I don't see the word gem. It used to be called gems the other day. Music to my soul says petitioning activity. This analysis was great. I hope so. I hope so. I do like all this research, and I can't really convey everything that I put into my brain, and sometimes I end up rambling. So I apologize. It's hard. And Sharon says, no, it's always been jewels, not gems. So, and yeah, we touched on this, Vito Mama, and it's the same point that, who just made, where was that one? That the Traveler just made, white people supporting civil rights, the public petitioning for pro-life or pro-choice. Exactly. It's ridiculous. More jewels. Thanks, guys. All right. So I think that's where we are ending on this. Thank you all for being here. Thanks for getting us over 70. Now just help us get over 100 or 200, whichever case may be. Hopefully it starts moving a little quicker with that here. I don't know. I keep hoping that you hit this number and then it's going to go places. Hey, Pisces, welcome. Welcome. We appreciate your support. Family hug. So thanks, everybody. Enjoy your weekend and catch you next time. Bye.
Absolutely.